Hello. Hello. Nói শুনা পাইছা? Hello. Hello. Hello নয়ন শুনা পাইছা নে? ক্লিয়াৰ আছে? হেল্ল' নয়ন শুনা পাইছা এতিয়া? ক্লিয়াৰ আছে নে? শুনা পাইছা? Hello. Check. Check. 1 2 3. Hello. শুনি আছে? এতিয়া শুনি আছে? Hello. Check. Check. Hello. Check. Check. Hello. Check. 1 2 3. Check. Hello. Check. 1 2 3. Check. What higher to the here?
Okay.
That application may be called.
We'll do one thing. We'll take up these order matters, apart from other upgraded matters, immediately at 2.
The application may be called. Application filed for making treasury a party.
Wait, please. Item 22, my lord.
Yes.
Lordship may not like to take up the matter.
Okay. Item number 20, not before me.
My lord, item number 30, matter password for the day. Bank account is out of this.
You're the petitioner?
Petitioner.
Why do you want it after Passover for the day?
My lord, he is out of this month. He engaged counsel. I'm appealing for it.
Item number 30, at the request of the petitioner, matter stands adjourned for 4 weeks.
Deeply okay.
Item 19. My lord, may be taken up after a week.
Item 19,
19.
at the request of learned counsel for the petitioner, matter stands adjourned for 4 weeks.
I'd like to mention item number 27, Lordship. Matter can you be taken up at 2, Lordship?
27?
Lordship.
Why?
Because speak for disposal today. Kindly be taken up at 2, Lordship.
Why?
Because speak for disposal today.
Okay.
Problem. My lord, in item number 14, the petitioner has got the relief, my lord.
1-4?
1-4, my lord.
Mr.
A Bhattacharjee, my lord.
Huh?
A Bhattacharjee.
Mr. A. Bhattacharjee, learned counsel for the petitioner, submits, and Mr. P. Naik appears for the SC Finance. The learned counsel for the petitioner submits that the petitioner has already got the relief for which the instant writ petition has become infructuous. Taking into account the same, the instant petition stands dismissed as closed as infructuous.
Lord, item number 34, Lord. I'm appealing for Department of PWD, Lord.
Yes.
But I'm appealing for adjournment of this matter, Lord. My instruction is awaited.
34?
Yes, Lord.
What does the other side say?
They have been informed. In the morning.
At the request of Mr. P. Naik, the learned counsel appearing on behalf of the finance as well as the PWD, matter stands adjourned for 4 weeks.
Number 1,
Yeah,
promotion.
please, your lordship.
Hmm.
Your Lordship, petitioners were the working as a temporary casual worker in the respondent department, Your Lordship.
Hmm.
Matter relates to the non-payment of fixed wages and remuneration as per the judgment of the state of Assam versus Upendas and others, Your Lordship. Similar matters were pending before this honorable court. Two similar matters, Your Lordship, where notices have been issued, Your Lordship.
Mr. Arkanan,
Taman.
Learned counsel for the petitioner. Madam, you are appearing for the PNRD?
Lordship N. Bora.
N. Bora
N.
appears on behalf of respondent number 1 and 3. Mr. P. Nayak appears for respondent number 2.
Your Lordship, there's one request, Your Lordship. Our matter may be tagged with the other two matters, Your Lordship. The other two repetitions are pending, Your Lordship.
Mrs. Ahmad, kindly don't make this unnecessary. This matter doesn't require so much of adjudication. I'm just issuing notice for this purpose. Issue notice making it returnable on when? Why the petitioner has not been given the minimum of the scale of pay?
Lordship. That is my
How much?
3 weeks.
3 weeks.
4
We'll
weeks. Lordship 4 weeks.
have it on 29th of May. Issue notice making it returnable on 29th of May 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 25th of April. The case of the petitioners herein that they have been rendering service for more than 10 years with effect prior to 1/6/2017, 1/8/2017. And as such, the case of the petitioners are duly covered by the judgment of the division bench in the case of State of Assam versus Upendas, dated 8/6/2017 in writ appeal number 45/2014. The grievance of the petitioner is that, however, the respondent authorities have not given them the minimum of the scale of pay as directed by the division bench in other similarly situated persons, to other similarly situated persons. The respondents on the next returnable date shall apprise this court as to why the petitioner has not been given the same, the minimum of the scale of pay. Liberty is given to the petitioner to mention the matter for upgrading the next day.
All right, Your Lordship.
Item number 2.
Yes, Mr. Amnat.
My lord, in this matter, the petition was placed under suspension in 2006, my lord. Then we approved the lordships, my lord. Lordship is directed, my lord, they should verify the documents, whether there is a charge sheet or dependent proceeding. And then pass the
Directing
order.
the respondents to pay their subsistence allowances from so and so till the date of his
Yes, they
reinstatement.
gain 50%.
When were you reinstated?
My lord, we are reinstated, my lord. My lord, after the High Court's order dated 1/2/21. But in the order of reinstatement, page number 42, may can be. Page 40.
Yes.
On the left side, can we have a look, my lord? This is the order written. Let me read this. After careful consideration of all the relevant records of the matter, the written representation of the officer, it appears that although Dr. Tapan Hazarika was placed under suspension, no department proceeding was drawn against the doctor. Not maintaining department proceeding against the delinquent should not make such a person eligible for pensionary benefit. And also, the doctor showed no intention to join government service from the date of suspension on 256. How can a person join, my lord? My lord, therefore, keeping in view the order of the Honorable Court, High Court dated such and such, the government of department pleased to pass the following order. Tapan Hazarika reinstated into government service from the date of taking over charge. Upon reinstatement, he is posted in such and such. B. Subsistence allowance is hereby granted to Tapan Hazarika as per 53 as such and such. This is given 50%, my lord. I have given the application to them also to reconsider that. And C, my lord, period suspension from 2516 to till date of reinstatement from the date of taking over charge in respect of Dr. Hazarika would be treated as on duty for pension purpose. So, my lord, these are 3 issues, my lord. Lordship may examine this matter. I don't have any interim prayer today. Just notice maybe issued.
You have retired?
No, I'm not. I'm working.
No, you have retired. No.
No. I'm
Then
not,
why is page 46?
my lord. There's a,
Request for pensionary benefits?
no, these pension benefits, because they've stated that particular person, that future, that period will not be. So my fear is that period may be treated in the future. But that's the reason, my lord.
You are still working.
Yes, my lord. I'm still working. My lordship, order me kindly page number, my lord, 40. Relevant part is page
And what is
39.
page 51?
51 is my lord. Similarly, situated doctor, my lord. Pays the suspension 1995, reinstated along with me, and he has got everything. He has got seniority, he has got promotion. I just an example, because of that I have given this document.
Oh,
my lord.
example.
Yes.
Yes, madam. Why the stepmotherly treatment to the
Exactly.
petitioner?
I will obtain instruction, Lordship. Lordship may issue notice, Lordship, at this time.
Well, Mr. M. Nath, the learned senior counsel, assisted by A. Bhattacharya. The learned counsel for the petitioner, Mrs. Arbora
D. Bora,
D. Bora, appears on behalf of the respondent number 1, 2, 3,
3 and 4.
4. Accountant General, where is he? No Accountant General. Did you see anybody in the Accountant General today? No. No accountant. None appears on behalf of the Accountant General on call. Accountant General Assam, the respondent number 5 on call. Although, as per the petitioner, the service has been, notice have been served upon the said respondent.
Name is also shown in there. Name is also shown. Stating Council AG.
Issue notice making it returnable on 31st of May. Enough time. 31st of May 2023. As the respondent number 1 to 4 is represented by Ms. D. Bora, Mrs. D. Bora, extra copy of the petition be served upon her by 25th of April 2023. As regards the respondent number 5, the learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner submits that the office of the Accountant General Assam has standing counsels, and he may be given the liberty to serve copies of the petition upon one of such standing counsel. Taking into account the same, the petitioner is directed to serve copy of an extra copy of the petition upon a standing counsel of the office of the Accountant General Assam. The case of the petitioner herein is that the petitioner was put under suspension on when?
My lord, he was facing suspension on 2506,
Where is it?
page number 32.
Was placed under suspension by an order dated 2/5/2006 pending drawal of departmental proceedings. However, there was no departmental proceedings initiated against the petition. In the meantime, on the basis of an order dated 13/3/2020 passed in WPC number 959/2020, the petitioner was reinstated. Now, the petitioner order dated so and so. This court
Page 13.
directed the respondent authorities to verify the next requirement to verify as to whether the further continuance of the suspension was necessary and to pay the subsistence allowance to the petitioner as per law. It appears therefrom, it appears subsequently by an order dated 1/2/2021 that the Principal Secretary to the Government of Assam Health and Family Welfare Department had passed an order observing that no department, or that although the petitioner was placed under suspension, but no departmental proceedings was drawn against the petitioner. It was further observed that not initiating departmental proceedings against the petitioner should not make such a person eligible for pensionary benefits. It was observed that the petitioner showed no intention to join government service from the date of his suspension on 2/5/2006. On the basis thereof, the Principal Secretary to the Government of Assam, by the order dated 1/2/2021, observed passed that the petitioner be reinstated into government service from the date of taking over charge, and upon reinstatement, he be posted as MNHO-Roman 1 at Sapua Para MPHC, Dorong. Semicolon. The petitioner be paid subsistence, the petitioner, semicolon, the subsistence allowance be granted to the petitioner as per FR 53 of FR and SR during the suspension period, and the period of suspension from 2/5/2006 till date of reinstatement from the date of taking over charge in respect of the petitioner will not be treated as on duty for pension purposes. The petitioner herein is aggrieved by the action, by the order dated 1/2/2021 for not treating the period of suspension as on duty, as till date there has been no, as admittedly till date there has been no departmental proceedings initiated against the petitioner. The petitioner is also aggrieved by non-payment of the subsistence allowance at the rate of 75% after 3 months of the initial period of suspension in terms with FR 53. The respondent shall, on the returnable date, apprise this court as to whether there has been any departmental proceedings initiated against the petitioner till date, and as to why the period of suspension should not be treated as on duty, and the petitioner be entitled for the arrears salary as well as for pensionary benefits, and further as to whether the subsistence allowance in terms with FR 53 has been paid to the petitioner. Liberty is given to the petitioner to mention the matter for upgrading.
Just one sentence per him.
Yes.
I also made a prayer here, my lord, for seniority promotion, because other persons, my lord, the duty does. He has given everything.
Let us get this first.
My
Lottery. Yes, Mr.
My lord, here is the case, my lord. The petitioner was appointed as a LP school teacher year 99, my lord. Thereafter, she obtained, my lord, junior basic training, my lord. He has given regular pay scale, my lord. Thereafter, my lord, I received my salary till February 2012. Then, my lord, from 2012 March, my lord, my salary have been stopped. Accordingly, it subjected a read petition. Then they made a notice to me, my lord, in the year 2014. Thereafter, my lord, after 14, my lord, thereafter they published a list, my lord, where I have been given clean sheet, my lord. By this time, I got retirement. I got retirement.
You got retirement.
Retired.
When?
I got retired, my lord, on 1/3/20.
And now are you getting your pension?
No, my lord, no salary, no pension, nothing else.
Are you asking for pension?
Salary as well as the pensionary. Area salary as well as my pension.
Heard Mr. J.I. Borgunia, the learned counsel for the petitioner. Mr. N.H. Khatuniar appears on behalf of the respondent number
1, 2, 4, 5, 6.
None appears on behalf of the finance department. No, Mr. H. Sharma appears on behalf of the respondent number 8. None appears on behalf of the finance department as well as the office of the accountant general AE, who are the respondent number 2 and respondent number 7 respectively. Issue notice making it returnable by 31st of May 2023. As the respondent numbers 1, 3, 4, 5, 6, and 8 are duly represented by the learned counsels appearing on behalf of the petition, are duly represented by the respective counsels. Extra copies of the petition be served upon them by 25th of April 2023. As regards the respondent number 2 and respondent number 7
7 is
and
there.
9.
Lordship, I am appearing for 7, Lordship.
Oh, you're
Our
not there.
name is not shown, Lordship, in the call. Our name may be shown, Lord.
Your name has been shown?
No, not shown, Lord.
So don't
So-
appear. They will serve you a copy. As the respondent number 2, 7 and 9 are not represented, the learned counsel appearing on behalf of the petitioner has submitted that the office of the finance department of the government of Assam, the standing counsel for the finance department of the government of Assam duly represents the treasury officer also, and as such, the petitioner is given the liberty to serve extra copies of the petition upon a standing counsel of the finance department. As regards the respondent number 7, also extra copy be served upon a standing counsel of the office of the principal accountant, office of the standing counsel of the office of the principal accountant general A and E. The case of the petitioner herein is that the petitioner have not received his salary from March 2012 to 1/3/2020. It has to be on 28/2,
No,
29/2. How can you get on 1st of March? You retire on 1st of March. Have not received the salary from the month of March 2012 to February 2020. And thereupon, the petitioner's pension as well as other pensionary benefits have not been finalized by the respondent government, respondent authorities, for which the instant writ petition has been filed. The respondents are directed to obtain instructions in the instant matter as to why the petitioner have not been given the salary during the period from March 2012 to February 2020, and also as to why the pension and other pensionary benefits of the petitioner have not been paid to the to the petitioner. Full stop. Liberty is given to the petitioner to mention the matter for upgrading on the next.
Lordship, regarding the respondent number 8, Lordship, most probably we have not been served copy.
We'll
Mentioned.
give you extra copy.
Yes, sir, so that we can obtain instructions.
In the cause list also, or their name may be shown, Lord, in the cause list. Lord.
Make a mention on the date when you appear.
Another 4.
Yes,
This is also for non-payment of salary, Your Lordship.
from
The service of the petitioner has been provincialized, Your Lordship, as due to with effect from 1/1/2021. Your Lordship. But till date, no such salary has been provided to the petitioner.
you have not got a single penny
No,
till now,
till now,
and you are still working.
Yes.
Why?
because I have made several applications before the.
Job is more important. Huh? Job satisfaction is more important than the income. There is a case. Yeah, there was a challenge to your
No.
selection.
That case was in the year of 2021, but my service was provincialized in the year of 2021. And the claim of the writ petitioner has already been withdrawn, Your Lord.
So that is the reason why. So there was some challenge
I
there.
think in this, in the state order, Your Lordship, there is no such order restraining the respondent from releasing the salary of the petitioner, Your Lord.
And when did you submit your representation?
I have submit my representation 22/11/2021,
When?
22/11/2021.
22/11/2021.
Yes,
To whom?
this is director, Your Lord.
Then
Thereafter, 1/33/2023, Your Lord. It is also
I then have been appointed, but ATN number so and so has filed the case seeking, but so and so Iman and for Iman. Court is dismissed and for Iman. Now, where is your claim in 22/11/2021 that you have not received your salary?
just 14, Your Lordship.
I've read it. Where is it? You have not
Here in
received
the
your.
prayer for enlisted the name into voices picture.
Understood. Where is the receipt? Where is your claim for salary?
The claim for salary, Your Lordship, he made prayer for enlisting his name into voice.
Huh?
That means the petitioner made prayer for enlisting his name into the voice list. Your Lordship.
Understood. Then that was given on 12/11/2021. Then
22/11/2021.
then after you woke up after 2 years.
In the meantime, Your Lordship, on several occasions, Your Lordship, the petitioner approached before the concern authority.
Then when is your last representation?
The last representation is 19, Your Lord.
When is the date?
30/3/2023, Your Lord.
So
In
you
the meantime,
expect
Your Lordship,
them.
in the meantime, Your Lordship, we made the approach before the district authority, Your Lordship.
Where? You have submitted a representation in 2021 only for enlisting your name,
Yes.
not for salary. Why did you do it? Why didn't you verbally say that?
This application is written, Your Lordship, at the petition.
Selection is illegal.
Voice list means, Your Lordship, he thought that if his name will come in voice list, then he will get the voice.
When did you inquire? After your representation on 33? Or did you come immediately? Or you didn't see it in your bank account? Which one? When did you come? When did you inquire? After this 33/2000? In the month of March you have approached. Then we have this Bihu. And immediately after Bihu, when did you file the petition?
We filed this petition on 10, Your Lord.
Eh?
On 10, Your Lord. But in my petition, Your Lord,
10. Within 10 days.
In my petition.
On
your-
12th, within 12 days, you have filed this?
Yes.
Very well. Then,
Herein, your lordship, I have made statement in my petition that.
we are asking for mandamus.
Yes.
So what is the necessity for asking for mandamus?
Necessity is refusal, your lordship.
Hmm?
The petitioner has already made his claim before the responding authority, but towards the claim.
Yes, you
no
made the
substitution.
claim only on 33/2023.
Prior to that, your lordship, in 2021 also.
You only said that your name be entered in the wage list. There was no claim out there.
Lordship, was this means your lordship,
Then-
petitioner.
You approach on 33 and immediately you file the writ petition on 10th.
That inclusion of the name of the petitioner in the voice list, you will get the voice.
No, Mr. Counsel. This is not done. Why? Why should this court at all exercise this jurisdiction? So you submit a representation and in the morning and in the evening you want to file the writ petition.
But in my petition, I have stated, your lordship, on several occasions, your lordship, representation 1/130
Okay, on several occasions, whom did you meet?
before the district authority as well as the director.
Where is that statement?
There's a statement, your lordship, page 6, your lordship.
Yes, where is it? What does it say?
Yes.
You have moved from pillar to post.
Pillar to post, your lordship.
Where, whom did you meet?
Yes, yes.
There?
That one, your
Have you met the director of elementary education
Syrian
on several occasions?
lordship, may I read the draft?
No, Mr. Counsel. Have you met the director of elementary education on several
Yeah.
occasions?
3 and 4, your lordship, I have written in my petition, your lordship. 3 means the DO of Golpara, your lordship, as well as the DO, your lordship.
No, Mr. Counsel. This is not
But-
satisfactory.
but-
This should come after some time. Wait for some time. You file the representation and immediately you come on 12th, one day before the vacation. Why?
Lordship, in my, shall you have a look at this, your lordship? Representation, your lordship, was submitted by the petitioner before the director, your lordship. That representation, the petitioner submitted by way of registered post because they refused to.
But this you send it by registered post, 33.
Yes.
My good.
Because they refused to accept the representation of the petitioner, your lordship.
And from where did you post it?
Lordship, kindly have a look at. I have stated that one, your lordship, that they refused to.
Where is your receipt, postal receipt?
Postal receipt, your lordship.
It's not annexed. There is a statement in paragraph 9.
9.
Then tell me, if you have done it from your place, no,
The
if you have done it from your place, as per the General Clauses Act, 7 days,
Yes.
which means 33, you post it, and it is on 6th.
The background. your
Only
lordship,
4
kindly have-
days. Only 4 days. You give time only for 4 days to the department
Lordship,
and then file a writ.
consider the background, your lordship, the petition approached before the.
You have
Your
not
lordship.
approached for salary prior to that. Where have you approached? Tell me, show me that document.
That is on 2011, your lordship.
Then 11.
Yes.
11, you were not appointed.
22/11/2021, your.
Then
Thereafter, your lordship,
22/11, you did not ask for salary. That you have not, have you informed that you have not received your salary at any point of time before 33?
the name of the petition in OS list, what it means.
Mr. Counsel, this court is not satisfied.
Enlisting the name of the petition in OS list, your lordship. I think it means, your lordship,
You file after
It's
some
not-
time.
getting the salary, your lordship. What I understand, your lordship, from this. Here. I understand from enlisting the name of the petitioner in the OS list, it means the petitioner is not receiving the salary, your lordship.
Then why haven't you submitted a representation then, thereafter? You have waited for 2 years. Why did you wait for 2 years?
Presentation, your lordship, is not made, your lordship. But if personally, your lordship, approached before the. But the question is that, your lordship, he is not getting the salary from 2021 itself. Here.
I dismiss the petition. Giving you liberty to file at a later stage.
Then I may be allowed to do, your lordship.
Huh?
I may be allowed.
No. I give you the liberty. Don't worry. In view of this representation which has been submitted on 33, and you have sent it by registered post, and the matter has been filed on 12th. So under such circumstances, I will give you the liberty to file at a later stage. That is what I'm saying. But I'm not going to issue notice as so soon. Heard Mr. A.M. Khan,
Yes.
the learned counsel for the petitioner. Mr. N.J. Khatoni appears on behalf of the Elementary Education Department. Without going into the merits of the case, it appears that it is only on 30/3/2023 that the petitioner had submitted a representation to the Director of Elementary Education, that too by way of registered post, as stated in paragraph number 9 of the writ petition. And immediately thereupon, on 12th of April, the instant writ petition has been filed. In the instant writ petition, the petitioner have sought for a mandamus. One of the prerequisites for issuance of a mandamus is that a justice has been demanded, which have been denied. However, it is seen that it is only after 4 or 5 days from the deemed receipt of the said representation that the instant writ petition has been filed. Considering the above, this court, however, is not inclined to issue writ at this stage. However, in the circumstance that the petitioner is not granted any relief upon their representation so submitted to the Director of Elementary Education, the petitioner would be at liberty to approach this court within a reasonable period. Five. Yes, Mr. Monto.
Deemed suspension, my lord.
Huh?
He was suspended, petitioner was suspended.
When?
Suspended, my lord, 29.
29/2022. Why?
With effect from, he was arrested in a criminal case, my lord.
When were you released?
He was released on, my lord, 9/9/2022. 9/9/2022.
9/9/2022 you were released, but you were suspended thereafter
Yeah,
on 29/2022.
yes, with effect from 3/8.
Okay, then
And I opposed, my lord, on 19/10, annexure 6, my lord, is 35.
1910.
And again on, my lord, on 10, sorry, on again on, my lord, 13/12, but still now, my lord, no search sheet, no, my lord, no
Prayer for
statement.
reinstatement. 1910.
My lord.
And 10 November in pursuance to the environment and grievances. For reinstatement on 13/12. 29. Then
And under
But a short date may be given. A short date may be given to obtain instruction.
tomorrow,
Whether
Monday, Tuesday.
Lordship on Wednesday.
See. Heard Mr. T.J. Mohanto, the learned senior counsel, assisted by Mr. P.P. Doctor. Mr. S.M. Hassan appears on behalf of the Forest Department, accepting notice on behalf of the respondent number 1, 2, 3, 4, and 4. Ms. A. Talukdar appears for the respondent number 5. Police?
Lordship, maybe standing counsel is there.
Police? No police. Is a standing counsel. Who is it? No idea. Okay. Issue notice. We'll issue notice to them by registered and. Yeah. Why are you making the superintendent of police a party?
Because my lord, he will, if required, my lord, he will place the instruction regarding the criminal case, my lord, commission of third sitting. And that can be by domain advocate.
No, why the respondent number 5 is required? Isn't this are you not challenging the suspension order?
Yes, I am telling the
So how does he have any role out there?
absolutely not, my lord.
Then you strike off his name.
All right.
Appears on behalf of the respondent number 1 to 4 and accept notice on behalf of the respondent number 1. Mr. T.J. Mohanta, the learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner submits that as the instant petition is only limited to challenging the suspension order dated 29/2022 and the further continuance thereof. The presence of the respondent number 5 would not be necessary, and as such, the name of the respondent number 5 may be struck off. Taking into account the said submission, the name of the respondent number 5 is struck off. The registry shall make necessary correction in that regard. Issue notice making it returnable on 28 April 2023. The learned counsel appearing on behalf of the respondent forest department shall apprise this court on the next occasion as to whether any departmental proceedings have been initiated against the petitioner. And further to that, as to whether the law as laid down by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India reported in so and so have been complied with. Liberty is given to the petitioner to mention the matter for upgrading. Get the instructions.
Supplemental is item 44 for motion.
Yes, Mr. Bora. This case, I remember.
Yes, my lord. My lord.
Water supply.
Yes, my lord.
You don't have a case.
I am not praying for any mandamus, my lord. My simple limited prayer is that consideration of my representation.
Oh, the consideration
of my representation, my lord. Because, my lord, apparently there is certificate issued by the concerned authority.
Mr. Bora, do you want this code to be painted red as a letterbox?
No, my lord.
Don't transform this code into this. No, nothing doing. Why should I issue a mandamus for all these things?
No mandamus, my lord. Only consideration of the because, my lord, he is
Mr. Counsel. The moment this code issues a direction, that is a mandamus.
My lord, kindly peruse annexure 2 and 3 the concerned authority has issued certificate that he has been working, my lord. Because he is
so what? You don't have an appointment letter.
Yes, my lord.
You have an appointment letter.
No, my lord. No, my lord.
Then why should I ask the authorities to consider you in respect to not others?
Because since the year 2015, he has been working there.
You have not been. You have been supplying.
Yes, my lord.
Supplying water.
Yes, my lord.
So
pump operator. He is the only pump operator. He is occupying the official quarter, my lord, in the year 2015, my lord.
You see the forest department?
No,
PHC department must be very kind enough to allowing you to stay in his
because if he had not performed his duty, my lord, nobody would have got water, my lord. Because he is performing his duties, my lord, on honorary basis, my lord. So therefore, I pray for sympathetic consideration, my lord.
Mr. Hassan, let me ask.
Till that he
is if it is so, then obviously I will direct. Is it your case? In any manner, is it the case of the PHE department that the petitioner is indispensable?
No, Lord.
See? But you say that nobody will get water without the petitioner. Then
yes, my lord.
They say that he is not indispensable.
No, my lord. Let him obtain instruction.
Without notice, issuing notice only he got some instruction.
Your lordship may peruse the proceeding, page 26, my lord. It is apparent, my lord, that only the petitioner is performing the duties, my lord. Only petitioner. The proceeding of the Pani Upabhokta Committee. He is the only person, my lord, performing here. And certificate issued by the concerned Gao Panchayat and the government Gao Pradhan, my lord. There also they have certified.
What is the Jol Mitra?
The post, my lord.
Oh,
Post.
somebody has already been appointed.
No, my lord. No, nobody has
One
appointed.
Nilamani
Lordship has the
starts.
appointment order.
No,
Huh?
my lord.
Done, na?
Lordship has the appointment order and
Yes. There's already been done. Engagement letter, Nilamani Das. You are engaged as contractual basis as per the terms and contract agreement as Jol Mitra volunteer for so and so. The
I'm not
monthly
aware of this, my
remuneration is 6,500. You shall report to the president of so and so. And interestingly, PhD department has no role now.
Yes, Lord.
They have already given it to a committee. What is that committee name? Wait.
Borongabari Pani Upabhokta Committee.
No, something else. President of Dohi GP is along with so and so W. What is the name of the committee?
Borongabari PWH.
Water Users Committee. Water User Committee. As per the decision of Nilamani Das was further sent to Department of Training of Jol Mitra held in ITI College situated at Dheragaon, and also Jol Mitra engagement letter was issued to him by the WUC. What is WUC? Water User Committee.
Water user.
Which was signed by the General Secretary and President. These are all being done by some private people. How can I issue a writ?
PhD only looks over the technical part. Construction.
They only look into as to whether anything out there. They have no business. You file a suit. Better off.
Yes, my lord. I was not aware of this development.
You give him a copy of it.
Yes, my lord.
You withdraw with the liberty to file an appropriate writ.
Appropriate form.
Yes, better off.
Yes, my lord.
I will keep this on record.
Yes, my lord.
You give him a copy.
And let him furnish me a copy, my lord.
Yes, please.
I'll do.
Heard Mr. D.P. Bora, the learned counsel, appearing on behalf of the petitioner. Mr. S.M. Hassan appears on behalf of respondent number 1, 2, 4, 5. Miss A. Talukdar appears on behalf. A. Talukdar for respondent number 3. The learned counsel for the PhD, respondent PhD department submits that the PhD department had no role in the appointment of the Jol Mitra, appointment to the post of Jol Mitra, which is exclusively being done by the GP/Water User Committee. He further submitted that in terms with the Jol Water User Committee have already appointed that the president the secretary, general secretary of the Water User Committee, along with the sectional officer PhD, who was a special invitee of the Water User Committee, have already appointed the respondent number 6 as the Jol Mitra to the post of Jol Mitra on contractual basis on 15/12/2022 itself. The learned counsel for the petitioner submits that he had no instructions in that regard. However, he submits that he would not like to press the instant liberty petition with the liberty to challenge the same, if so advised, in the appropriate forum. Taking into account the same, the instant petition stands dismissed on withdrawal. However, the petitioner, if so advised, is at liberty to approach the appropriate forum wherein private disputes could be adjudicated upon, wherein factual disputes could be adjudicated upon. The copy of the instructions were produced by Mr. S.M. Hassan as as well as the copy of the engagement letter of the respondent number 6 are kept on record and marked with the letter X. The learned counsel for the PhD department is directed to furnish a copy of this instruction as well as the engagement letter of the respondent number 6 to the counsel for the petitioner.
Oblige, Your Lordship.
And number 6 and 7 for admission.
2011, 2010. Yes, such old matters.
Yes.
We see such old matters only in
10, 11 matter, Lord.
civil bench one.
Only problem, Lord. I'm apologizing. Lord, senior advocate Mr. DCK is appearing in this matter since very long, Lord.
Let him appear. Don't worry. What is there? Why the matter was before the division bench saying and again has come back?
It refers to the case related to the question of pensionary benefit, whether the old pension scheme will apply or the new pension. The government came out with a executive instruction that from a cutoff date in 2005, new pension scheme will apply. We challenged that one, saying that a rule, we are guided by the rule of 69, and no rules can be amended by an executive instruction. During the pendency of the writ petition, they have amended the rules itself. Then we challenged the rule. That's why it was before the division bench.
Then why is it before a single bench?
No, now with the single bench was because, my lord, now we have given up the question of validity of the rules. Even within the rules, we are entitled to the benefit. That's why
So-
it has been.
So
referred to the-
2011 writ petition is
It
not
has traveled, my lord, so much.
2011 is challenging the rules.
2008, 2011. It was the pendency of the writ petition.
Now, what is this 2011 writ petition?
Another bench, Lord. One bench is there in the.
My lord,
and another
Your
bench in
lordship,
the
please to take, my lord, the next item. WPC
Government servant
670.
joining the post of remand shall not be. What have we challenged in the 2011 writ petition?
The same thing, my lord.
No. Then why there are two writ petitions?
Two writ petitions was because of the different persons. And the
Issue a
case-
renewal directive should not be issued declaring that the clause incorporating the terms and conditions of appointment notification dated 29/2005 the effect that government servant joining the service of the state government on or after remand shall not be governed remand in area. A writ in the language should not be issued declaring the impugned notification memorandum shall not be illegal. The remand should not be set aside. The impugned notification dated remand and notification dated as so and so. A writ of like nature declaring the So you are leaving aside the prayer 3 and 4. You are not further agitating. You are not claiming the prayer 3 now. Page 20 of your writ petition in 2011.
Yes, yes.
You are not on that.
Notification 14/7/2008.
14.7 is that 2A being brought in. Rule 2A.
Oh.
So you are not on that. Now you are challenging the scheme?
Now, we say that, my lord, even under the rules, we are entitled to the benefit of the old pension.
Very well. So you are neither challenging the office memorandum,
No,
nor you are challenging the rules.
no,
You say that on its own,
on its own.
your appointment was prior to 1/2005. And as such, you are entitled to.
Yes.
Very well.
The appointment was not made, but my lord, selection was made before that date.
So
And
you come under.
By fortuitous circumstances, some persons were appointed before that date, and we happen to be after that date.
Oh,
After that.
That the division bench judgment
Is that division bench judgment?
by Justice Thuli and Justice
Yes,
Sumitra Saikia,
Yes.
following the judgment of Swapan.
Delhi High Court judgments and Uttarakhand High Court judgments and several judgments.
That judgment is Swapan Das or something. What is the name?
Sanjay Kumar.
Sanjay Kumar is the Delhi High Court judgment.
No, here right.
Here is the Delhi High Court. The other is.
Premananda Jadhav. Premananda Jadhav main case for the select.
Premananda Jadhav, Delhi High Court, several, about 9 cases were there before the and one judgment was there about Inspector Rajendra Singh. I'm handing over a copy to a lot.
No, in that Sanjay Kumar judgment, it has been duly noted those two Delhi High Court judgments.
All this.
Okay.
That is my case.
Now here there was a advertisement issued.
This was before in 2000, my lord,
2003.
Yes.
2002.
2002.
And then the selection process?
Selection process started. Interview was held in 2003. And the PSC selected in 2004.
Select list was published.
Yes, select list was published.
Then?
In 2004.
But your appointments were given after 2005.
First batch was appointed before 2005. We are in the second batch. And third batch followed. But nobody came. We were in the second batch. Some people came. And it happened to be after that day.
So, Mr. Nagwa, how can this court help you?
The order judgment passed by our division bench is distinguishable from this particular case. That judgment passed by the division bench, it is distinguishable from these facts of this case.
How?
In that case, all the persons were within the number of vacancies notified. Some persons were appointed. In some cases, it got delayed. In this case, Lordship, advertisement was issued on 5th June 2022 for 100 numbers of posts, 80 for junior engineer civil and 20 for junior engineer civil PW building, 80 for roads, 20 for building. A select list was sent by the APSC. In that list, Lordship, there were more than 100%. So so far as the notified vacancies were concerned, Lordship, we given them appointment, and that was prior to coming into effect of the new pension scheme. So they got the benefit of old pension scheme law. Subsequently, Lordship, when future vacancies arose, these remaining persons were.
But how did you have the same select list?
Lordship, APSC and at that point of time, Lordship, FRBM Act was also not there, in spite of several Supreme Court judgments were there, Lordship. But they followed the same select list.
As they did it for the Operation Blackboard.
Yes. So unless somebody else challenges their appointment, Lordship, we at least in the department we cannot do anything, Lordship. But in spite of that, Lordship, that will remain. So far as the notified vacancies are concerned, they were given appointment. They were given appointment prior to the coming into effect of the new pension scheme. They are getting the old pension scheme. But these are all future vacancies, Lordship.
Without a selection process.
Same select list.
Same select list, but the advertisement was only for 100.
Yes, advertisement was for 100.
And how many people were there in the select list? Means as per this is done under 4F or what is that?
No, it's regular.
APSC does under what?
Regular appointment.
Understood. 4.
No, not 3F.
No, not 3F. 4.
Permanent vacancy.
Regular
vacancy.
Regular vacancy, there is a Lordship, Act Lordship, rule Lordship. That under that rule Lordship.
As per the rule, how many people can be there in the select list?
Double of the vacancy. Double of the vacancy.
So against that 100, there were 200 posts.
There were the subsequent requisition from the FPSC Lordship. It was diverse during the course of the hearing division bench. Apart from 100, there are another mechanical engineer vacancy were also requisition to the FPSC. On that basis, Lordship, total, I have that instruction.
So this requisition was made prior to that period?
Requisition of junior engineer total.
The requisition was for 100 posts only.
2003 Lordship requisition. 2003, in the year 2003.
Okay.
And we have recommended 270 total.
270,
270.
which means there were 140, 135. This will be against 135 then.
Double of the
If you have recommended 270, it will be 135. So how did these other people get appointed?
is up to the government lordship.
Oh, the government have done.
From that select list, government
No select list, nothing.
Same select.
How can they? They have only recommended 270.
270.
No, Lordship, in the first batch, 108 numbers were appointed. Second batch, 84. And third batch, 46. So total is 108.
But how many posts have been requisitioned to the APSC?
108 lordship.
Not 108, 800 Lordship. Advertisement was for Lordship. Advertisement is before Lordship.
Where is it? In which case do I find the advertisement?
If you Lordship, please to take up the next case.
11.
2010.
2011.
2010.
2010.
Yes. Next item number 7. 6700.
2002 has had. In 2010 petition, Lordship will get the advertisement at page 23.
2010.
Page 23. The relevant portion is at page 26.
Page 27?
6.
26. Wait, 23 the advertisement is. Assam Public Service Commission is defined as when so post is
Down below, Lordship. Following post under RNB Government of Assam.
where?
Page
Page
26.
26.
Page 20, yes. Bottom part. Start from the middle. Law. Following post under RNB Government of Assam. 80 posts of junior engineer civil under PW Road. Then Lordship will see at 2, Roman 2, 20 posts of junior engineer civil under PW building wing. So that was the advertisement. And it was an advertisement of the year 2002.
And what are the earlier ones on top? 3-1 following post in the Directorate of Assam Institute of Research.
Those are different departments. Advertisement was same, but different department. We are concerned with
the PWD.
yes.
Okay, these two, 80 plus 20.
Yes.
80 plus.
So this is 100.
100.
Now what happened?
The first batch they appointed about 108.
The petitioners participated against that. Where is the select list?
Select list is at page, my lord, 50.
What is 39?
39 is the,
This is the appointment.
no, the appointment is page 50. The select list is at page 39.
Page 39 is the appointment.
No, it is select list.
No,
No,
page
no, no.
40 is the appointment. This is the first batch started.
First batch.
28th of October 2004.
October 2004. This is 100.
108.
How did you do 108?
5 posts, I think 8 posts subsequently
Added.
added.
Very well. Then those
Lordship-
people happen on 9/5.
Lordship will see the page 51.
Page 51.
Lordship will kindly see the date 9th of February 2005.
That I've seen it.
In
Then
this lecture, 84 number of persons were appointed.
84.
Yes. And 1/3 list is there, Lordship. That list is there in the second petition. One more list is there. In the next petition, your Lordship will get.
Oh, these are different.
Yes.
These are not from here.
Now, some persons belong to list 2.
Second list and some person from the third.
And in that petition, persons belonging to third list are there in the second petition.
Okay.
11.
So second and third.
Third
Second
is,
and third list.
Third is there. In
So 84 and 48.
84 and 46.
46. These
First
people are
108,
there.
Second 84 is the second list. Third 46, that is the third list.
Fantastic. So what is the challenge out here? Written nature should not be issued, impugn notification of 2011.
Lordship will see in the advertisement, Lordship, there is a condition annexed, dear Lordship, that mandatory condition under new pension scheme, Lordship.
Where? Not in the advertisement, it couldn't have been.
No,
Because
in
you
the-
have
in
taken the
in
decision.
in the select list, Lordship.
No, in the select list it is. Because you have taken the decision on 25/1/2005.
Yes, sir. Page 51. Page 51 of the first report.
That I've seen it.
That condition is
Because
there.
that comes from 25/1/2005.
That is under challenge. At least published in the month of February, Lordship, 2005. And that is why that condition was there.
So your case is, if it was the case of those 108, if they were appointed subsequently also,
No. They were, they,
yes, if they were appointed subsequently also, by virtue of the judgment in Sanjay Kumar, they would have got the old pension scheme.
so far as the
But
notified
in
vacancies
respect
are
to
concerned,
these posts,
future vacancies. I am using the word future vacancies. Lordship will get that phrase, Lordship, in so many judgments.
but future vacancies arose when?
Subsequently, Lordship.
When?
That is not concerned.
Now, when was the
They-
requisition made?
Lordship,
APSC?
what I'm submitting, Lordship,
Hmm.
they cannot claim parity with the first batch, Lordship, because those were within the notified vacancy. That is the judgment passed by the division bench, our division bench. Lordship. And the contrary judgments are also there, Lordship. Even Delhi High Court judgment passed several judgments, Lordship, on that point. Those are contrary judgments. Lordship, I am going to place one judgment passed by the Allahabad High Court also. There it has been specific.
But Allahabad has been said to be not good
Yes, it is.
by the Sanjay Kumar judgment.
No, Lordship, that was not considered, Lordship. But in that case, Lordship, all the persons were belonging to the same select group, Lordship, and in respect of the same notified vacancy.
And all these people gave undertaking also.
Yes.
When was the requisition made, Mr. Counsel?
Lordship,
For the remaining 84 and 46 posts?
Lordship, that instruction is not clear. Lordship, and
Huh?
that instruction is not
After
clear.
13 years, you don't have the instructions for that?
No, Lordship.
No means what?
We are issued letter, Lordship.
Then why was this matter pending for so many years?
in the meantime, it went before the Supreme Division bench, Lordship, and it again returned. Now, Lordship, only prayer, Lordship, they are saying that that undertaking is not applicable to us, and secondly, that subsequent amendment is not applicable to them.
But Mr. Das, would it be proper or prudent on the part of the petitioner to give up the challenge if you don't come within the ambit?
So initially, of course.
See, the question is like
The
this.
point they are raising now,
Hmm.
they did not take it up in the affidavit of it.
Because you have a big problem now, one thing. Earlier, that problem was not there. The judgment by which YV Rangaya
Yes, why will Rangaya has gone?
has been gone, this creates further problem to you. Earlier it was there,
Earlier it was there.
that if the vacancy arose then,
Yes,
it is the rules of that will follow.
follow.
Now with the Rangaya gone, you have an additional problem. Now should you leave that challenge to that statutory act rules? Earlier you had a good case.
Yes.
But if those vacancies, as regards the vacancies which arose, I think that by the time when the matter came up before this court, it would have been.
Initially, that rule was not under challenge. But
Initially,
subsequently,
the rule was.
when we produced by filing an affidavit, that the rule has
Understood,
been
but
amended.
whatever may be, there is a challenge. The challenge has not yet been withdrawn. Have you withdrawn it?
No, they're not.
That
It
is what
there,
I'm
but
saying.
a submission has been made that they are not pressing that.
But would it be prudent, Mr. Das, You have heard him.
Yes.
His specific contention is that Sanjay Kumar would have otherwise applied. If it is a case where 108 people, or 100, more particularly 100, these 100 were appointed even after 1/2/2005, because that is against the notified vacancy, which was the advertised. These 84 and 46, there was no fresh selection, which ought to have been done. But the government have taken a decision. Why should we go into all these things? We'll adopt the same select list.
Yes.
So we will do it. So this was never a part of that advertisement. That is the specific step, those posts.
But
Sanjay Kumar.
In that case, my lord, nobody has challenged our appointment.
That is what.
And my lord, the Supreme Court has said, even in cases where the appointments were challenged, subsequent appointments were challenged, the Supreme Court said, my lord, in several cases, that no, their appointment cannot be set aside.
No, Mr. Das, that is not the point. The appointments not being challenged is a different thing. You are appointed, you continue. But by that time, the office notification has come. The office order came, the policy decision was taken on 25/1/2005.
Yes.
Wherein it was a direction by the chief secretary, by the director of finance to everybody, and they look here that henceforth all advertisement, all appointments, wherever you are doing, in the advertisement, you have to mention that they will be coming under the new rules. Even in the appointment orders also, you have to mention, and there has to be an undertaking being given. Subsequent thereto, in 2009, this amendment, the new pension scheme was brought in.
Yes.
And in 2011, this amendment, because they felt it necessary, they knew it, by way of an executive instruction, you cannot take over the mandate of the rules. So by that, they have to come up with this amendment.
Yes.
Now you have challenged that amendment to Rule 2A. You have challenged it here. Are you going to leave that? If that is the point which they are canvassing. I think about it. Better off. If you leave it, as of now, it has only come from upstairs to downstairs.
So far as that challenge prayer is concerned, Lordship, a judicial order is there, Lordship. They are not pressing for that challenge, Lordship. That order is there, Lordship.
Order is there, but then also they may think about it. It is already there in the petition. If they want to challenge it,
Lordship will find that order.
What your lordship will please to consider, that if that is strictly followed, there are 100 posts advertised, but in the first batch, more than 100 were appointed.
108 were appointed.
Yes.
Understood. These 8 has got the benefit out there because they were appointed to a substantive post at that point of time.
Before that.
Before that. But as regards the other people who were brought in, that was never a part of the advertisement.
Let me think it over.
Where is that order? There has to be an order somewhere.
Yes, one order was there.
Yes. Learned Senior submits that now the petitioner have given up this challenge and they are not pressing on that. Since there is a request at the bar, particularly from the Learned Senior Counsel for the petitioner, that although there are primarily service matters, the reason why they have matters have come to the division bench entirely is the petitioner have also challenged. For the petitioner submits that now the petitioners have given up the challenge and they are not pressing in this. Now this matter be considered by the single bench.
That is correct. But I have a separate point, of course, subsequent point. Possibly that may have. But
Because that was before the same bench
Yes, yes, separate.
who had given Sanjay Kumar,
Yes.
and you must have submitted then.
No, it was Sanjay Kumar later on. Sanjay Kumar was later on. That is possibly before this. Sanjay Kumar.
I think Sanjay Kumar came on just 2-4 days before Justice Dhulia left.
4th February 22.
4th
4th February 22.
February 2022. Yes. Yes. Because I think that was a Saraswati Puja, some puja or something like that. Just 2 days before this has happened. Now this is on 10/11/2021.
Oh.
Now, they want to distinguish Sanjay Kumar on the basis of Sanjay Kumar was in respect to death post. Sanjay Kumar, there was a delay of 14 months. And then also the court said that irrespective of this 14 months there being a delay, but you have started with that and you have to end it. But did you have a right to remain in the select list? Have a right to remain, to be appointed?
No, appointment, I don't have a right.
Now, if you didn't have a right, would you still continue to get the benefit?
Our only contention is, my lord, the selection process is the same.
Mr. Das, have you looked into my judgment on old pension, new pension? There, I think you have a look at, because the same contention was made as regards in Operation Blackboard. And there I have dealt with Sanjay Kumar and all other aspects. That's reported now in 2023 SCC online. (1165). You look into that. There, I have dealt with this issue. That is why I've grasped up this matter, because I have dealt with this issue. Look into this. If you can find out something better off. Otherwise, the big problem arises if you don't have a right to be appointed on the basis of that select list, because that is why I asked the APSC people as to how many select person needs to be put in the select list against how many vacancies. Now, as per them, it is 2 times. So if it is 2 times against 100, there will be 200. 8 just went out, got the benefit of it. There has been a delay for you, but you were not against those vacancies.
Subsequent vacancies. But the question will arise, my lord, herein also, when the requisitions were made.
There the problem arises. Requisition was made was helpful when Rangaya was there. You should have got this matter done prior to this Rangaya being taken over. That is why I said Rangaya was the only thing. Why wouldn't you could have very well said that the vacancies arose, requisition was made then.
Yes.
But then with the requisition, as per the APSC norms, they were supposed to issue an advertisement.
That is correct. But the government can take a decision, of course.
Like Himachal government has done it yesterday. They reverted everybody who were into this NPS into the old OPS. So when will you have it? We don't delay this matter because it's a 2010-11 matter. It doesn't look nice.
Doctor, this is the only one issue. Doctor. I have some other points of on the next day we will take.
What are the points?
Today I will not try to table. On the next day, Doctor, I will.
Why? Let him get prepared for that.
I don't want to give the senior advocate a chance to prepare.
No, Mr. Nayak, this is not expected.
In the second week of May, Lord.
No, this is not expected. What are the other points? Let him also have a know what is it. Then he can come. Then we can get a better thing. Don't think that you are to get a judgment for the sake of it. Get a judgment for justice. Yes. What are the other points? Let him know. You also be fair to him.
Not if pension is a condition of service. Lord.
That is already there. Condition. It's not only a condition. It has to emanate from the statutory norms.
Yes. Not if and condition of service becomes a right only after appointment. Judgment is there. He is claiming something, Lordship, that was prevailing prior to his appointment.
Don't you think that Sanjay Kumar had taken that?
Lordship, some cases is there, but Lordship will also consider. In the rule, no exception is there. The rule itself is an exception to the pension rule, Lord, the amended rule. Rule does not provide any exception. One cutoff date is there that has been upheld by the Supreme Court. One amended rule is there that has been upheld by the Supreme Court.
Which amended?
New pension scheme.
2A has been amended, has been upheld.
Not our one, Lord.
Some other. Cutoff is absolutely the prerogative of the executive. The court cannot look into it. No worry with that. That quarrel, I think T. Sampat.
Yeah, Sampat is there.
That
so far as that date is concerned, Lordship, there is an statutory there. Either this way, or this side, or that side.
But what do you say then in Sanjay Kumar? What has happened?
Sanjay Kumar, Lordship, one exception was created, Lordship. But as I have...
Our exception has been created.
Yeah, that is not applicable. That is the...
No, you see, how Sanjay Kumar happens or any other judgment of the Delhi High Court had happened is on account of the laxity on the part of the officials, which led to this delay.
Lordship, a person
But we
was
have to
selected.
find out, my lord, whether they exceeded the vacancies or not. Whether in all those cases, whether it exceeded.
No, that is not there.
That is not.
Lordship, even I can place judgment by the same Delhi High Court, Lordship, where it has been held that delay was not because of the authority.
But Sanjay Kumar is a delay by the authorities of 14 months.
Both the judgment and Lordship. Both the judgment, Lordship will consider.
No,
Why
Delhi.
Sanjay Kumar alone, Lordship?
No, not only. You see, I am bound by the Sanjay Kumar judge.
No, that is why I am submitting, Lordship.
I am not bound by the Delhi High Court or Allahabad High Court saying anything. No. The Delhi High Court judgment, I am bound. Our division bench, I am bound by that. But I'm not on that. But the reason why Sanjay Kumar happened is because of the laxity on the part of the respondents,
yes,
which have resulted in delay.
Yes.
So that is the only otherwise the reason why. But in this case, the right to get pension is based upon, is not on the basis of an appointment. It is based upon us right. It is based upon the condition, fulfillment of the conditions of the statute. If you don't fulfill this, matter ends there.
Yes. Let me take it up.
Second week, Lord.
Yes, second week.
Why second week? This is a small matter. I don't think there's so much matter.
No, only dilemma, Lord. If I don't want to bypass my senior.
Huh?
I'm not trying to bypass my senior. Let him come, Lord, in the second week of May.
Oh, that is his lookout. One year he wants to come or not. I am not on that.
Second week only, Lord.
Mr. Nayak, it can't be at the convenience of anybody. We'll have it on 2nd of May. You said second, I kept till second.
Second week, Lord.
2nd of May.
Second week, Lord.
Second.
Second week.
Mr. B.C. Das, the learned senior counsel, assisted by Mr.
Yes,
So and so. And Mr. P. Nayak appears on behalf of the PWD department, Mr. PP Doctor appears on behalf of the APSC. You get the instructions when these things happened. Requisition made. The case of the petitioners herein is that that in the year 2003, an advertisement was issued.
2002,
2002? 2002, an advertisement was issued. I'll give the date. Wait. What is the date of the advertisement? An advertisement on 5th of June 2002, an advertisement was issued by the Assam Public Service Commission for filling up a vacancy of various posts in various departments, including 100 posts in the department and under the RNB Government of Assam. The petitioners, pursuant to the said advertisement, duly appeared before the duly participated in the selection process and were included, and their names were included in the select list. Although there were 100 posts which were advertised, but by a notification dated 30/10/2004, issued by the Governor of Assam, 108 persons who were in the select list were given appointments. Subsequent thereto, it reveals that there were further requisition made by the government of Assam in the PWD department, by the PWD department, bracket RNB, bracket RNB, for requisition of another 84 and 46 posts. However, the government, the APSC did not conduct any fresh selection. However, the APSC did not initiate any fresh selection proceedings, but made recommendation on the basis of the earlier select list, wherein the petitioners in both the petitions featured. Thereupon, on 9th of February 2005, and on a subsequent date, the petitioners were duly appointed In these appointment orders, in the notification, so appointing the petitioners herein, it was categorically mentioned that the petitioners would come within the ambit of a new pension scheme, which would be formulated in terms with the contributory pension scheme announced by the government of India. The case of the grievance of the petitioners is that as the advertisement was issued prior to (1 to 2005), which was the cutoff date for the new pension scheme, their case is covered by the judgment of the division bench in the case of Sanjay Kumar versus Union of India, reported in (2022) SCC online GAU 214, as well as the judgment of the Delhi High Court in the case of Shyam Kumar Chaudhary versus Union of India, reported in 2019 SCC online Del 11891. It is, however, relevant to take note of one relevant aspect of the matter, that in both the petitions, there was a challenge to the amendment made to the challenge to the insertion of Rule 2A to the Assam Service Pensions Rules 1969 by the amending rules as notified by the notification dated 14/7/2011, as well as also the new defined contributory pension scheme 2009, as was issued by the office memorandum dated what is the date of the office memorandum? 6/10/2009.
I mean, this is the amendment.
Office memorandum.
6/10/2009.
Yes, I remember. 6/10/2009. However, it is relevant to take note of that on 10/11/2021, next thing. Taking into account that there was a challenge to a statutory rule, the matter was before the division bench of this court. However, as recorded in the order dated 10/11/2021 by the division bench, wherein the learned counsel appearing on behalf of the petitioner had given up the challenge to the amending rules. And as such, the matter has been placed before this court. The learned counsel appearing on behalf of the PWD, however, had submitted that the right to pension would depend upon the fulfillment of the conditions as stipulated in the Assam Service Pension Rules 1969. And as the petitioner's appointment happened after 1/2/2005, and as the amendment to the rules of 1969 was brought into effect retrospectively with effect from 1/2/2009, 1/2/2005. The appointment, the petitioners cannot claim to be appointed, cannot claim to be entitled to the old pension scheme in terms with the rules of 1969, but would only be entitled to the new pension scheme. The learned counsel, Mr. P. Nayak, had further submitted that the judgment in the case of Shyam Chaudhary as well as Sanjay Kumar would not apply to the facts of the instant case, in as much as it was in respect to, if it was in respect to those 100 posts, if the petitioners came within the petitioner's appointment was made within the 100 posts, which was advertised on 5/6/2002, then only the judgment in the case of Sanjay Kumar Supra would have been applicable. However, the petitioners herein were appointed against subsequent requisition being made, which was not a part of the advertisement. And as such, the judgment in the case of Sanjay Kumar Supra as well as Shyam Chaudhary Supra would not be applicable. This court further made a query upon Mr. P.P. Datta, the learned counsel appearing on behalf of the APSC, as to when was the requisition so made by the PWD department. The learned counsel, however, submitted that he would require to take instructions in that regard. Taking into account that the matter has been heard at length, let the matter be again listed on 2nd of May 2023, on which date the learned counsel appearing on behalf of the APSC shall apprise this court as to when the requisition was made by the PWD department and also for further consideration. Mr. Das, think about it.
Check 27 to 23, Lordship. Lordship, in that Lordship, Honorable Court directed to the inspector of
Lordship,
school.
Lordship, I had a talk with the inspector of schools, your Lordship. Lordship, what they are saying is that they have no record as of now whether the respondent has filed any petition before the education tribunal. Your Lordship. They have found no record on that.
Lordships, today I got the instruction that respondent number 6, Lordships, he got retirement on 30 July 2020, Lordships. His date of birth is 30 July 1960, Lordships. And also, I have submitted an affidavit. In that affidavit, it is clearly stated that soon after the school was taken over.
No, here is the case. Let us not go into all these things. Why the salary has not been paid?
Lordship.
What is your stand? You file affidavit.
No, we have not filed your Lordship.
Why?
We have filed your Lordship.
Yes. What is your stand?
Lordship, page 40, your Lordship. The government by letter number so and so requested our office to submit a detailed report on the status of Bala Nath, and accordingly, our good office directed the inspector of schools Dorong to submit a detailed report by this office letter number so and the inspector of schools submitted a report which was communicated to the government. Now the matter is before the government to issue necessary instruction on the matter of releasing or withholding the salary of the petitioner.
What happened to the WPC number 955/2013?
Lordship, that is also disposed of.
What has happened?
Lordship, that order, Lordships, I have annexed page 22, Lordship.
Page 22.
Lordship, page 22, Lordship. WPC 955/2013, Lordship.
Now, what decision has been taken by the authorities on in terms of the order dated 28/10/2013?
Lordship, an inquiry report was given, your Lordship.
When?
Inquiry report is at page, Lordship.
Page 24.
Lordship.
What has happened there?
There it has been stated that respondent is senior, your Lordship.
Build on the basis of the relevant
Paragraph 13, your Lordship.
Now, what happened thereafter?
Lordship,
After the inquiry report?
Lordship, after the inquiry report, the provincialization order in favor of the petitioner, that was withheld, your Lordship. That was not given effect to.
Then,
your Lordship, another writ petition was filed, your Lordship. 4828 of 2015.
Who has filed? Mamta.
Lordship.
The petitioner therein had filed.
Lordship.
Then what happened?
Lordship, in that order, your Lordship, this honorable court had send it to the education tribunal, your Lordship, because under section 19(2).
Where is that order?
Lordship, that is not annexed, your Lordship.
Okay. Then what happened? Has sent it to the.
Lordship.
You have a copy of that order? You are a part of that petition?
Lordship, I have.
Then why have you not brought on record that order?
The affidavit in opposition has been annexed, your Lordship.
Then what happened?
Then, your Lordship, That was the that was asked in the last order, Your Lordship, whether any case was filed before the tribunal or not.
Now, what about this 2015 order?
Then we have the 2015 order where it is stated that it is in favor of the petitioner, Your Lordship.
The above so-and-so is recalled. The order dated hold the field and so is entitled to receive salary on the basis of a provincialization from 17/8 and approval of the finance department by letter dated so-and-so. Then what happened? (2015). Now, what is your stand thereafter?
Thereafter, Your Lordship, contempt petitions were also filed by the petitioner.
That is okay, but what has happened thereafter in compliance to the Honorable Court's order filed by Mumtaz Ali? This office by the order dated September 2015. This happened another, when was this order of, yes, 4828 order came only on 19/8 after the order of 26.
Lordship.
So 4828 order is very relevant. Why haven't you brought on record that? Don't you think that is a very important order? Mr. Sharma, isn't that the most important order in view of the affidavit filed? Because your order to get from 17/8/2013 is based upon the order of 26/2015. But subsequently, there is an order passed by this court on 19/8/2015 in 4828. Why that order is not a part of the record? Then, therefore, what happened? Filed by Sri Mumtaz Ali by this court and dated demand. Office order dated 5 September 2015 withdrew the earlier order dated 7 July 2015 wherein the provincial was given to the petitioner. Subsequently, the government was requested to issue necessary instructions on the matter by the government by so-and-so requested to our office to submit a detailed report on the status of the, and accordingly our directed the inspector to submit a detailed report by demand. The insurer submitted the report which was submitted on, communicated to the government by demand. Now the matter is before the government to issue necessary on the matter of releasing withholding. Why haven't you brought on record these orders? Why? What is this hide and seek business?
It should have been annexed, Lordship.
You also admit,
Lordship.
but your office does not.
Lordship. Lordship, this was filed by some other counsel. Lordship, here I pray for some time, Your Lordship, to get an updated instruction, Your Lordship. So what had happened after this?
Heard Mr. R. Sharma, the learned counsel for the petitioner, and Ms. D. Musari, the learned counsel appearing on behalf of the respondent, Secondary Education Department. It transpires from the affidavit in opposition filed the Director of Secondary Education Department filed on 3rd of January 2023 that there is a reference being made to various orders being passed by the various orders in paragraph number 9 of the said affidavit in opposition by the respondent authorities. There is also a reference to an order dated 19/8/2015 passed in WPC number 4828/2015. However, none of these orders have been enclosed to the affidavit in opposition. The learned counsel appearing on behalf of the Secondary Education Department submits that permission may be liberty be given to the Secondary Education Department to bring on record those documents by way of an additional affidavit. Taking into account the same, let this matter be listed again on 17th of May. In the meantime, the respondent Secondary Education Department shall place on record those documents as referred to in paragraph number 9 of the affidavit in opposition, along with the order along with also stating the present status of the pension of the salary proposal of the petitioner.
Obliged, sir.
27.
Please, Your Lordship.
Yes.
Your Lordship, this case may be disposed of in the light of the decision rendered in Sanchita Roy, Your Lordship, reported in 2019 to CL 805. Yeah. नहीं कपट के
Because we have filed an affidavit, my lord. Here we have stated that rejecting 18 years, that's 6 years, 18 years, 3 months. So now, if we calculate, go by that, it's 20 years plus.
20 plus 24 years.
And in fact, we have forwarded this to the AG. They have rejected, not us.
They have, because you have not done anything.
Modified
The pension department have not done anything pursuant to Sanjita Roy. And that is why people are coming right, left and center. And you have troubled this person to approach this court, didn't it?
Yeah.
However, they would, the lawyers won't mind. Mr. The learned counsel for the petitioner, Mr. Ardhor, appears on behalf of the PWD department, PWD, rural routes, PWD, and Mr. R. Mujumdar
For the respondent number 6.
appears for the
Accounting.
account office of the accountant general, and Mr. H. Sharma appears for the director of pension. Mr. R. Borbujari appears for the commissioner for the finance department. The case of the petitioner herein is that the petitioner was initially herein is that the husband of the petitioner was initially engaged for a period of 3 months, but by re-employment order dated 28/12/1992, his service was extended until further orders. The husband of the petitioner service was regularized by an order dated 7/10/2005. Subsequent thereto, the husband of the petitioner retired on 31/3/2017. The husband of the petitioner, in the, it is further stated in the petition that the husband of the petitioner received GIS and the leave encashment. But he did not receive his pension. Unfortunately, the husband of the petitioner expired on 14/6/2018. The petitioner thereupon approached the respondent authorities, claiming the area pension of the petitioner, of the husband of the petitioner, along with other pensionary benefits, as well as also for the family pension. The same having been denied, the instant writ petition has been filed. The relief sought for in the instant writ petition is for a direction upon the respondents to pay the area pension of the husband to which the husband of the petitioner was entitled to with effect from 1/4/2017 till the death of her husband, that is on 14/6/2018, semicolon, for a direction to the respondents to release the area family pension to the petitioner with effect from 15/6/2018 till date, as well as to continue making payment of the family pension this court, by an order dated 23/1/2023, issued notice making it returnable on 22/2023, and further directed the counsels appearing on behalf of the respondents, more particularly the respondent number 2 and 3, as well as the respondent number 5 and 6, to apprise this court as to why the petitioner has not been paid the area pension as well as the family pension. When the matter was listed on 22/2023, it was brought to the attention of this court that the PWD department, the PWD, Public Works Department, wherein the husband of the petitioner was working, had not submitted the proposal to the respondent number 5. Considering the same, this court again fixed the matter on 3/3/2023, on which date the learned counsel for the respondents were directed to obtain instructions from the respondent departments pertaining to area pension, pensionary benefit, as well as the family pension to which the petitioner claims to be entitled to. It further appears that on 13/3/2023, there was no instructions received. The PWD, the learned counsel appearing for the PWD, again sought for time. to obtain instructions. And accordingly, this court fixed the matter again on 23rd or 29th of March 2023, on which date the PWD was directed to apprise this court as to whether the pension proposal of the petitioner has been sent to the office of the Accountant General. The learned counsel appearing on behalf of the Accountant General AE was also directed to apprise this court as to whether the PWD had sent the pension proposal to the office of the Accountant General. Thereupon, the matter was fixed on 29/3/2023, but the same could not be taken, for which the matter has been directed to be listed today. It appears from the records that the respondent number 2, who is the chief engineer of the PWD Roads Division, had filed an affidavit on 27th of March 2023. It was mentioned in the said affidavit that the petitioner, husband of the petitioner, was initially appointed on 1/8/1992, was initially employed for 3 months by an order dated 1/8/1991. Subsequent thereto, the husband of the petitioner was re-employed as unskilled master role. MRL is what?
Labor. Master role labor.
Master role labor for 3 months. By an order dated 1/8/1992. And after a lapse of 9 months, his service was discontinued for the aforesaid period of the appointment order. It has been further mentioned that after the expiry of 3 months period, as on 30/10/1992, the husband of the petitioner was again re-employed on 28/12/1992 and until further orders with immediate effect. And further, his service was regularized by the government as on 22/7/2005. And since then, he has been working till retirement. It further appears from paragraph number 7 that the husband of the petitioner, that the reason why the petitioner's husband was not given the pension was due to was due to the reason that the husband of the petitioner was re-employed as unskilled MRL on 28/12/1992 with immediate effect and until further orders. And since then, he has been working continuously. Hence, his service counted with effect from 28/12/1922 was 18 years, 3 months, 3 days after deducting 6 years initial service of MRL as per the office memorandum dated 18/3/2010. It was further mentioned that the pension papers of the, what is the husband's name? Of the husband of the petitioner was submitted to the higher authority on 24/4/2018 in pursuance to a government letter dated 6/2/2018. At that relevant point of time, the husband of the petitioner expired. And after the expiry, the chief engineer PWD Roads Assam returned the pension papers of the husband of the petitioner with instruction for resubmission of the pension for family pension. And then the pension paper was submitted in respect of the petitioner. To the chief engineer PWD Roads Assam for onward submission to the government, as well as the accountant general AE for sanctioning the same by the letter number 23/11/2020. It has been further mentioned that the accountant general had finalized the pension case, whereby only sanctioning the terminal gratuity. It has also been mentioned that it is on account of the office memorandum dated 18/3/2010 and the circular of the accountant general AE numbers dated 6/3/2013, wherein it is laid down that the total qualifying service less 20 years are not eligible for pension gratuity. To the said affidavit in opposition, filed by the respondent number 2, an affidavit in reply has been filed by the petitioner, wherein reference was made to the judgment of the coordinate bench in the case of Sanjita Roy versus the state of Assam and 4 others, reported in 2019 to GLT 805, and more particularly to paragraph number 30 and 31. Whereby it has been held that a deduction of a period of 6 years while computing the pension, while computing the qualifying service, was not permissible. Today, when the matter has been taken up, Mr. R. Ahmed, the learned counsel, appearing on behalf of the Office of the Principal Accountant General AE Assam, placed on record an instruction being issued by the Senior Accounts Officer Legal Cell, wherein it has been mentioned that it is on account of that the petitioner is entitled to the relief in terms with the judgment of the coordinate bench in the case of Sanjita Roy, Supra. But as no office memorandum has been issued by the respondent authorities, the benefits of the said judgment could not be given to the petitioner. The copy of the said communication is kept on record and marked with the letter X. I've heard the learned counsels for the parties and perused the materials on record. Who is for pension? and finance. Yes, Mr. Dhar, you also. What is this 20 years business? When he is confirmed in a government post, he was confirmed in the government post on 2005 or 7. When?
2005.
7/10/2005. He worked till 2017. If he has worked till 2017 and being confirmed in a government post, would he be not entitled to the pension accordingly? Irrespective of Sanjita Roy and all? Sanjita Roy will only come in respect to that office memorandum which I showed it to you yesterday, wherein the 20 years is given. Where are you getting this 20 years otherwise? Yes, Mr. Saikya. Where is this 20 years coming from?
Qualifying service is 10 years.
Understood. That is it. Then where is the 20 years coming from?
From that circular minor.
Huh?
That office memorandum, my lord.
Absolutely, from that office memorandum. That is in respect to a person who is not confirmed.
Yes.
That is that.
Yes.
20 continuous years of service in an unconfirmed post. But when a person is already confirmed, and wouldn't he come within the ambit of the new rule, this particular rules?
It is the government who created the all provisions by deducting 6 years of service from the qualifying service. They have deducted.
Where are you getting this 20 years? Yesterday also I have been asking.
20 years goes from my lord that earlier office memorandum, whereby my lord the period of 6 years was my lord directed to be deducted.
No. Where? Which is this office memorandum?
So that office memorandum.
That is only for unconfirmed. A person who is not regularized.
But for confirmed persons, my lord, there is no such. But it has been followed that all master roll workers, because here is a case, it has been confirmed. Normally, my lord, master roll workers, they are not confirmed.
So
in majority
for
of
them
the
it is
cases.
okay. But how do you bring in Sanjita Roy here?
Otherwise also he will be entitled.
He will be entitled because he has been confirmed in the post. So the moment he is confirmed, wouldn't it date back from to the date of his initial appointment in 1992? And his period of service will be taken from 1992 to 2017. And his pension has to be done on the basis thereof.
Only thing, my lord, is that there should not be any break in the service.
No, it is clear that there is no break in service from the 1992 onwards.
Very much. Because the spirit
No, that is what because it is only in rule 134 the 20 days of service is there. Nowhere else.
Yes, but authorities are precisely following that office memorandum, even except the deduction of 6 years, which has been interfered by the Honorable Court.
So here is a case where a person has been confirmed, the question of this office memorandum does not arise. Or this 20 years business. He will come under 108. I've heard the learned counsels for the petitioners, parties, and have perused the materials on record. It is an admitted fact, as could be seen from the affidavit filed by the respondent number 2, that the petitioner has been in continuous service with effect from 28/12/1992 and he was confirmed by an order dated 30/9/2005. The husband of the petitioner, no, the husband of the petitioner, husband. The husband of the petitioners subsequently retired on 31/3/2017. Therefore, his period of service pursuant to the confirmation order dated 30/9/2005 would have to be counted from 28/12/1992 to 31/3/2017 for the purpose of pension. Which would be how much?
Almost 25 years.
Huh?
Near about 25 years.
Don't give me all these things. How much? 25 years, 8 and 25. Less than 25 years. Which should be so much years, months, and days.
I'll give.
The services of the husband of the petitioner pursuant to his confirmation on 30/9/2005 would come within a pension, within the ambit of a pensionable service in terms with the Assam Service Pension Rules 1969. In as much as the requirements as stipulated in Rule 31 of the Rules of 1969 are duly met. Considering the above, the husband of the petitioner, therefore, would be entitled to pension as well as other pensionary benefits which any other government servant of corresponding rank would be entitled to. Further, upon perusal of Rule 140, Rule 139, (140) and 143. The petitioner herein would be entitled to the family pension. In that view of the matter, this court therefore disposes of the instant writ petition, directing the respondent authorities to pay the arrear pension to which the arrear pension and other pensionary benefits which the husband of the petitioner would have been otherwise entitled to had he been alive. the area pension from 1/4/2017 to 14/6/2018, as well as other pensionary benefits which the husband of the petitioner would have been entitled to had he been alive. And further, the area family pension from 15/6/2018 till the date of the instant judgment, and further to continue to pay the family pension to the petitioner as per the mandate of law. The said exercise be completed by the concerned respondent authorities. That is the respondent number 1, 2, 3, and respondent number 6. Within a period of 3 months from today, within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number 2 as well as the respondent number 6. It is, however, made clear that while disbursing the pension as well as the pensionary benefits, the amount so paid to the petitioner, who got the money? Terminal benefit? You got or your husband?
No, I got.
Which have already been paid to the petitioner shall be deducted while deducted.
Period of service comes out to be 24
What?
years. Period of service for 24 years, 3 months, 3 days.
Already 24 months.
24 years, 3 months, 3 days.
You wanted 25.
31.
Yes, Miss. Yes, Mr. Doctor.
My lord, I could not get the instruction, my lord. I have talked to the commissioner, my lord, sometime back also.
PWD.
No, my lord, this is personal department. My lord, they said that they need further at least 2 weeks time.
Is agreed by the office memorandums dated so and so and so and so. Further to the petition also agreed by the order dated passed by the respondent, which is contrary. It's contrary to the directions passed by this court in so and so. You want how much time?
My lord, another 2 weeks, my lord. They said, my lord, that this last couple of weeks, there are a lot of holidays, so people are not there. And this is also almost, it's a holiday, my lord. So another 2 weeks, my lord, I would need.
Mr. A.K. Datta, the learned counsel for the petitioner, Mr. Ardho appears for the respondent number 1 and 2. The learned counsel submit for the respondent number 1 and 2 submits that some more time is required to obtain the instruction as sought for in the order dated 15/3/2023. Lists the matter again on 22nd of May 2023. So it is made clear that on the said date, the learned
I will file an appeal with the order.
learned counsel for the respondent number 1 and 2 shall ensure that the instructions are received.
33.
Oh, this one? Suspension?
Suspension, Lordship, and your Lordship has directed us to file an affidavit showing that the so-called notice has already been served upon us. Lordship, we do not have such, as because it was sent through post, not registered post. Accordingly, we are unable to, and his plea is that it was never been served upon him. So, Lordship, it will go.
But it will go.
Your Lordship will see the last order, my lord.
10-4.
So have you prepared the memorandum of charge?
Memorandum of charge has been prepared. Lord.
Where is it? Why you have not been able to serve it to the petitioner?
Lordship, it was sent through post.
Understood.
And as
Doesn't the
because,
petitioner appear? Now, a person who is suspended, doesn't he have to come to the office sometime?
Lordship, that instruction I have not taken, but
No, isn't it required?
but Lordship, it was sent through post when it came to their knowledge, as because after his arrest, Lordship, when the sanction was sought for by the investigating officer, then only we came to know. Accordingly, he was put under suspension. Thereafter, Lordship, it was sent through post. And as he did not reply to the so-called this so-called, accordingly, the departmental inquiry was the inquiry officer as well as the presenting officer were appointed, and they were directed to hold the inquiry, Lordship. But his plea is that he never received that so-called notice.
He never received or he have never served. There's a difference.
Lordship.
Which one is?
But that is the Lordship, as because I have inquired whether it was served through registered post or not. They have stated that no, it was.
So they are not interested in serving, but they were interested in suspending.
So, Lordship, that is the.
Huh? No, isn't it a serious case where it's a case under the Anti-Corruption Bureau? And your officials are not serious? Which department is this? Deputy Commissioner?
My lord.
Lordship.
Huh?
Lordship. He's a Latmondal.
Understood, Latmondal, but why is the government, Deputy Commissioner is so not serious about this thing?
Lordship, they otherwise.
Is he in hand in glove with the petitioner?
I don't
Or just
so,
to
Lordship,
show to the people that we have done something?
Initially, thereafter, Lordship, on 29th of October.
Are you not paying him 75% of subsistence allowance?
It should have been paid, Lord.
No, why are you paying him?
That is it.
A person not working? Isn't it a liability of on the government to keep him suspended?
Lordship.
Then you recall what you are saying? Is the liability of the government?
I have been told that it was sent through post. So accordingly,
No, send to post means you are going to put it on a simple post. Doesn't these people understand the necessity? Isn't he a deputy commissioner? After all, he's in charge of the district.
Lordship.
Then, and Mr. Dotto, your revenue, are you not the head of the revenue department? Doesn't the deputy commissioner comes within your ambit? Is this the conduct of a deputy commissioner? On one hand, there is a case under the ACB.
PC Act.
PC Act, this is the Anti-Corruption Act.
Lordship.
And then also you are not serious. You have an office memorandum of 4/2/2020 issued by the Chief Secretary asking you, yes, it is being issued by the Chief Secretary, asking that every time, every 3 months, you are to submit a report why a further continuance is required. Then also. Or is the Deputy Commissioner above the Chief Secretary? I don't know.
No.
He's not. Then I think the Revenue Department, the Secretary, Commissioner and Secretary to the Revenue Department is under the Chief Secretary, I suppose.
Yes.
Yeah. This is the state of affairs. Is the Deputy Commissioner out there who is also in charge, is charged under the same case? No. ACB is not a part of that criminal conspiracy.
No.
Then why is he not serving the suspension order? When were you suspended, Mr. Talukdar?
My lord, your lordship will find in the suspension order at page 31. Was passed on 29th of October 22, giving retrospective effect from 26/8/22. So from, if we count from 29th of October, then also, my lord, today, November, December, January, February, March, April, 6 months, my lord, have gone.
No, Lordship, yes, because it is on 29th of October 2022 order, whereas it is evident on perusal of the report of say so and so investing officer, inspector of police, vigilance and anti-corruption, Assam, say Ranjit Goswami Lotmondal was arrested on 26/8. On that day, they came to know accordingly this suspension. But Lordship, regarding this issuance of the so cause, that it was sent to simple post.
No, you are not sent to post. Where is the proof to that? You have sent it to post.
That is the difficulty.
You don't have that also. You must have put it in the symbol in the letter box.
It seems to be like that. Thereafter, 30th of November, that this so-called notice was issued. Yes, issued. Thereafter, as because he failed to submit his reply.
Why the affidavit has not been filed?
Affidavit regarding that, your lordship has directed us to file the affidavit.
Because I remember this matter when it came up on the last occasion, just 2 days before.
Yes.
You said that no. This matter today, it will be difficult if it is taken up on 19, because 3-4 days it is a holiday.
Lordship,
I said that no, nothing doing. Then we'll have it on 21st.
Yes, and we have been.
Then why haven't you filed an affidavit?
No, lordship has directed us to bring on record, to file affidavit, bringing on record in SI documents as well as to indicating thereon as to when the memorandum charges was served upon the petitioner. As because you do not have any proof, that is why we have not filed, Lord. That is the reason. Otherwise, I could have filed it.
You file it 25th.
By
Deputy Commissioner.
It will be matter of knowledge. By matter of knowledge.
No, let him file it. We'll then put the Deputy Commissioner to notice why he has been so in such a manner, why he is doing it, why he has taken it. I will indicate what you are saying out here. Because tomorrow they may say that he had no instruction to say, that it was sent by simple post. How are you keeping a person out here in suspension? Do you have a copy of that so-called notice?
Yes.
Show me. I hope you have not imposed a minor penalty upon him.
Statement available.
Mr. Sharma, have you read the so-called notice?
Yes, sir.
When did the Deputy Commissioner get the power of the criminal courts? Huh? To inflict penalties under 7A of the PCA.
Lordship.
Is this a so-called notice?
And Lordship,
You are going to impose penalty. I hope the Deputy Commissioner knows that the rules of 64 applies.
Lordship.
You are going to impose penalties which are given in Rule 7. How can the Deputy Commissioner or the Disciplinary Authority impose penalty under 7A of the Prevention of Corruption Act? Permissible?
No.
The Revenue Department, the Deputy Commissioner has taken the power of the judicial authority also.
Yes, sir. In another cases, I have asked it to this effect. They said that the personal department has prepared a format. On that format, they have said that.
Can he be sending a format under 7A of the Prevention of Corruption Act? Why any of the penalties prescribed under 7A of the Prevention of Corruption Act should not be imposed?
It should be why DP should not be initiated.
Huh?
It should be why DP should not be initiated.
No, not only that, they may ask why penalties under 7 of the rules of the sickness. But does he have the power to impose penalties under 7A? And this, on the face of it, this the notice is useless. We'll have it on 28. You file your affidavit by 26. Through the Deputy Commissioner. Heard Mr. S.K. Talukdar, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma appears on behalf of the respondent number 3 and 4. Mr. S. Dr. appears for the respondent number 1 and 2. This court, by an order dated 24/3/2023, sought instruction from the respondent number 3 and 4. Sought instruction from the respondent number 3 and 4 as to whether there has been compliance to the judgment of the Supreme Court rendered in the case of Ajoy Chaudhary versus Union of India, reported in 2015, 7 SCC 291, as well as the office memorandum dated 4/2/2020, issued by the Personnel Department of the Government of Assam. When the matter was listed again on 10/4/2023, the learned counsel appearing for the respondent number 2 and 3 and 4 had submitted that the memorandum of charge was issued in the month of November 2022. And the petitioner, in pursuance to the said memorandum, have not submitted the reply and pursuant thereto in terms with Rule 9.4 and Rule 9.5 of the Assam Service Discipline and Appeal from Rules 1964. The disciplinary authority have already appointed the inquiry officer as well as the presenting officer. To the said submission, the learned counsel appearing on behalf of the petitioner had strongly refuted the receipt of any memorandum of charge by the petitioner. Under such circumstances, this court had directed the respondent number 3 and 4 to file an affidavit bringing on record the necessary documents as well as also indicating therein when the memorandum of charge was served upon the petitioner. This court further directed that the affidavit be filed by 19/4/2023 and accordingly had fixed the matter on 21/4/2023. In spite of the said direction, the respondent number 3 and 4 thought it prudent enough not to file the said affidavit. Today, Mr. H. Sharma, the learned counsel appearing on behalf of the petitioner, respondent number 3 and 4, submitted that they have no records, that the respondent number 3 and 4 have no records, that the memorandum of charge / the charge sheet have been served upon the petitioner. During the course of the hearing, this court had inquired what is the status as to what is the so-called notice which have been issued. It shocks and surprises this court at the contents of the show-cause notice, in as much as the deputy commissioner who had issued the show-cause notice have asked the petitioner to show cause as to why penalties prescribed in Section 7A of the Prevention of Corruption Act 1988 should not be inflicted upon the petitioner. This court is surprised with the fact that the rules of 1964 mandates a particular procedure, mandates the manner in which this departmental inquiry is to be conducted. Rule 9.2 to Rule 9.11, Rule 9.2 to Rule 9.10. In an unambiguous manner, stipulates what is required to be done. It astonishes this court that a person in the high office of the Deputy Commissioner, Karimganj, is not aware of such requirement. This court is further perplexed to see the contents of the show cause notice. Inasmuch as the punishment which the Deputy Commissioner, the disciplinary authority, that is the Deputy Commissioner, seeks to impose upon the petitioner is a punishment which is a punishment reserved for the criminal courts to impose, and not by a disciplinary authority in exercise of the powers under the rules of 1964. Taking into account the same, now this court further would take note of that the allegations so made against the petitioner as would appear from the first information report as well as the order dated 28/9/2022 in ACB PS case number 34/2022 is serious. And however, the manner in which the disciplinary proceedings are acting, however, the manner in which the disciplinary authority in the instant case have been resorting to take action would have a serious impact in the administration, in carrying out the administration in a manner which the government otherwise professes. Taking note of the above, this court therefore directs the Deputy Commissioner, Karimganj, to file an affidavit explaining his conduct.
Lordship, I have a prayer, Lordship. May I pray that Lordship may fix it on May 2nd, Lordship?
No.
Till 24th, we are closed, Lordship.
So what? That is why I'm asking you to file it on 26.
26, Lordship. So I have to obtain the instructions on 25, then 26, Lordship. May I pray only for these 2 days accommodation?
Okay.
Only May
But then
2nd,
we'll
Lordship.
ask this person to be personally present. We'll explain him.
No, Lordship. I must have to call him and have a talk with him, that person, and to
No, we'll ask
file
him
the
to be
affidavit.
personally present, then we'll see, because this is a serious thing. Because
Lordship, yes.
I'm endorsing this order to the Chief Secretary also,
Yes, Lord.
because something needs to
I
be done
appreciate, Lord. But only this much of accommodation.
to explain his conduct in the manner of, to explain his conduct, and to explain. Explain the above. First, list the matter again on 3rd of May 2023 at 2 p.m.
I will file by 20.
The affidavit be filed by 28th of April
Lordship.
without fail.
Much obliged.
Or not, and Ajay Chaudhary has been followed or not. I don't have any written instruction, Your Lordship, because the offices are closed, but I've been able to get some verbal instruction that actually charge sheet has not been issued, Your Lordship. May I pray that to get the written instruction, let be fixed on next week. That way I will get the written instruction, and then the Lordship may be pleased to dispose of the matter there and then.
Twenty-eight.
20?
Mr. C.S. Hazarika, the learned counsel, appearing on behalf of the respondent number 2, 3, and 4, submits that he requires that he have been verbally informed that till date no memorandum of charge have been issued to the petition. However, he submits that he would like to take the said instructions in writing. Taking into account the same, let the matter be listed again on 28th of April 2023. Liberty is given to the petitioner to mention the matter for upgrading.
Obliged.
36.
Your Lordship, for suspension matter adopted. The last of
My lord, suspension order was reviewed, my lord, within 3 months, my lord, and it was extended, my lord.
Where is it?
My lord, we have not the file affidavit, my lord. We can file the affidavit, it can be bring on record by way of
You have served the memorandum of charge.
Charge has not yet been issued, my lord.
Then how are you reviewing it?
My lord, reviewing it on the basis that the instruction from the deputy commissioner and the police, my lord, report whether what is the FIR has all been lodged, my lord, against the petitioner. What is the, my lord, search sheet has been filed or not? What is the status of the investigation? All these things are queries has been made to the divisional forest officer by the principal chief conservator of forest, my lord, and that has been waiting, my lord. So it was extended.
What is the allegation?
Locus notice, page 22, Your Lord. Regarding collection of money. Providing jobs.
Is 25 also, Lord, will look at it. Asking to file FIR against the petitioner, my lord.
Now, has the petitioner submitted reply to that?
Lordship, I have submitted my written reply, Lordship.
When?
I have submitted on Lordship 22/12/2022, Lordship. I was asked to submit within 3 days, Lordship. But before that, suspension order was passed. And I have also preferred an appeal, Lord. That has also not been disposed of, Lordship.
You have submitted your reply.
Lordship.
Where is it?
Annexure A, page 27.
Thereafter, Lordship, I was released from my present job and was posted at another office, Lordship. Annexer G, page 28. Then I'm posted in the new office, Lordship.
Then what remains?
But my suspension has not been revoked yet, Lordship, and I have not been paid a full amount of salary also, Lordship. Regarding lodging of FIR, I am unaware of, Lordship.
No, you have been posted in some other place.
Well, he has been attached in the, my lord, in the office of the head office, my lord.
No, and he have been asked to join your duty immediately, meaning whether the suspension still remains.
Suspension still remains, my lord.
How?
Well, the petition was placed under suspension pending drawal of departmental proceeding.
Understood.
Departmental proceeding has not yet been initiated, my lord.
Understood, but see the order at page 28?
Page 26.
28?
Page 26 is the order, my lord.
Page 28.
If you also look into page 26, my lord.
Understood, but 28?
No, he was, my lord, released from that, I think.
And asked to join.
My lord, that may not be.
But they may not be. Where's the suspension then?
Suspension order is page 26, and the headquarter of the incumbent is fixed at DFO, Silvetta Division, Hills.
This is done as pending completion of inquiry and submission of so and so. You are hereby placed under suspension with immediate effect as so and so. The headquarter of the incumbent is during the
office
review.
of the DFO, Karbi Anglong West Division, is fixed at DFO
during the period.
Council Division, Hills, DFO during the period.
Yeah. Now this you have changed.
That my range officer cannot change it, my lord. The range officer cannot change it. He is the range officer, and it was issued by the special principal chief conservator of forest, my lord. And he is the range officer. So in pursuance of that, he was released to so that he can attach in the office of the DFO, my lord, so that he cannot go to the.
But what do you mean by the word asked to join your duty immediately?
My lord, that may not be a correct word.
Then where is the suspension? One hand you have not
my lord, range
initiated.
Officer, my lord, range officer is the
in Karbi Anglong, does the rules of 1964 apply?
My lord, it is followed, my lord.
Apply. So you have not given the memorandum of charge?
No, my lord, till date.
So where is the question any further?
My lord, my lord, it is a criminal offense is there. FIR was lost against him, my lord.
Oh, you are to submit your memorandum of charge for that.
My lord, if it is, my lord, it is both the criminal proceeding and the departmental proceedings, if it is the same set of facts, my lord, so we are waiting for that, my lord.
Waiting for the criminal proceedings to end.
No, my lord, we will not wait, but what is the stage of the investigation and the document and the person who is adducing made the statement against the petitioner that she had collected the money from those persons, my lord.
So you are going to gather your information from the police and then issue the memorandum.
That, my lord, as without the proper instruction, my lord, I cannot submit it like that way, my lord. But as the, my lord,
then if you don't have instruction, only instruction you have that there is
today.
no memorandum of charge,
my lord,
then how can this court sustain your suspension order? Tell me.
my lord, suspension order was reviewed on the ground that the proper documents from the office of the divisional forest officer has not yet been received.
Now, does Ajay Kumar Chaudhary judgment say about the review prior to memorandum of charge being issued? No.
No. Within the period of 3 months, my lord, the order of suspension is required to be reviewed.
No.
That's
says within 3 months you are to submit the memorandum of charge.
Sorry.
And thereafter you are to review by a reasoned order. That is it. To him, para 21. Give it to him.
memorandum of charges and oblique charge sheet. If the police issued the charge sheet against the petitioner, my lord, within the period of
No. The charge sheet is meant in respect to a disciplinary inquiry because it is to be served upon the delinquent. Is a charge sheet served upon the delinquent? No.
Direct that the currency of suspension order should not extend beyond 3 months if within this period the memorandum of charges oblique charge sheet is not served on the delinquent official employees. If the memorandum of charges charge sheet is served, a region order must be passed for the extension of the suspension.
In both ways, there is nothing. Let us assume you say that charge sheet is a charge sheet in terms of 173.8.
My lord.
Then also it is not.
My lord, that instruction I don't have, my lord, whether police issue the charge sheet or not, my lord.
Not necessary because Mr. Duty, kindly tell me, is it the contemplation of the law that a charge sheet has to be served upon the delinquent employee? No, it can't be. And we can't assume that the Supreme Court doesn't know that aspect. So when the Supreme Court means a memorandum of charge, oblique charge sheet, it has to mean a charge sheet in respect to a disciplinary proceedings. And that has been understood everywhere.
But in that aspect, my lord, in the other Chaudhary's case, probably, my lord, in respect of when the criminal proceeding is pending or the complaint is pending, that aspect has not been considered, I think, in the other Chaudhary's case, my lord.
But that has been taken note of in the case of Rekibuddin
by
a division bench. And recently, in Rekibuddin's case, also the Supreme Court, there was a reference sought for, which was also negative. How can I help you?
No, if your lordship gives me 3 days time, my lord, I'll file a affidavit to that extent, and lordship may dispose of it in the next Thursday. I'll bring it on record, my lord. What transpires in the, my lord, official records, my lord. But my instruction is the charge sheet has not.
What is your problem in issuing the charge sheet? See paragraph 22.
My lord,
see paragraph 22.
My lord.
Of that judgment. Take the benefit of that.
Suspension order has already been reviewed and it has been extended. Lordship, I understood the point, my lord.
Review will only come once a memorandum of charge is served.
My lord.
Unless you don't serve it automatically in view of the first paragraph, it goes. But if in the case if you submit the memorandum of charge, because there's the Supreme Court say that be that as it may, the law have been declared. But however, the petitioner would not get the benefit because in the meantime, the memorandum of charge has been served. Take that benefit. You are not doing it. Mr. Dutta has taken that benefit in one case and issued it on 17/3/2022. Isn't it?
Yes, that's it.
Yeah. You can very well put the charge out there. You have not done it. And otherwise, you don't leave any scope for this court to decide. The question of a review does not arise prior to that. See, Ajay Chaudhary is a judgment where Article 21 has been brought in.
But in the Ajay Chaudhary's case, in my respectful submission, when that if it is in the forest related case, forest offense is also there. At that case, search sheet has been filed by the police. But those aspects regarding those cases also not has been taken into consideration. We have cases regarding the forest offense, regarding the posting of rhinos is there. When the person was suspended on that basis, under the forest law, it is required to be referred to the judicial magistrate. It was referred, judicial magistrate issued the offense has been taken report. But in that case also, my lord, other story came into play, and that if departmental proceeding is not initiated, but the search sheet, but the offense report has been taken into consideration by the magistrate.
You already have that so cause.
My lord.
Why don't you make it in a memorandum? That's all. And do that very well. Where is the concept in the rules of 1964? Is there a concept of issuing a so cause for whether to hold the departmental proceedings or not. No. That is there under the CCS rules. This concept is foreign to 1964, what you have done. This so-called which you have issued is foreign. And it has to be in terms with Rule 9 too. Mr. P. Wardlow, the Learned Counsel for the petitioner, and Mr. J. Chutiya, the Learned Counsel, Standing Counsel for the respondent number 2, 3, 4, and 5. Mr. J. Chutiya, the Learned Counsel, appearing for the respondent, submits that he requires an accommodation of 3-4 days so that he can file an affidavit in the instant matter. Accordingly, lists this matter again on 28/4/2023. Liberty is given to the petitioner to mention the matter of reading.
Obligation. 39.
Yes, Mr. Sharma.
Lordship, although the district elementary education officer, Dhubri had sent the career salary proposal on 4th of March, Lordship, to the office of the director, and during the process of verification, certain shortcomings were found, Lordship. Certain documents were not there, certain information were further required. And the director of elementary education has, by communication dated 20th April, has directed the district elementary education officer to furnish those information and documents.
How much time?
Lordship, it will require some time, Lordship,
How
because
much?
the district elementary education will further submit all the documents.
2 months.
Lordship.
Mr. R.A. Ahmed, the Learned Counsel for the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department, who submits that that pursuant to the verification process, it was found out that some further documents would be required. And as such, the Learned Counsel for the Elementary Education Department seeks for further time in the instant matter. Accordingly, lists this matter again on ধৰি নাথাকিলে এইখন ঘূৰাই দিয়ক এপ্ৰিলখন ঘূৰাই দি মেখন ৰাখক very good. This matter again on 12th of June 2023. On which date Mr. P.N. Sharma, the Learned Standing Counsel for the Elementary Education Department, shall apprise this court as regards the proposal for enhanced grade pay to the petitioners.
40.
The pension matter, my lord. It is fixed on 27. Here, my lord, after retirement, he informed that he has stayed for more than 1 year. They filed an affidavit in opposition saying that Treasury has not passed that GPF amount, and also the
no, there is one IA filed by whom?
Filed by us, my lord.
Huh?
Filed by us.
For what?
For impleading Treasury officer as part. Because government affidavit is that the Treasury officer has rejected the GPF amount, and they have also not paid the provisional pension. So your lordship will, the matter was fixed on 27. Mr. Gogoi is out of station.
Who?
Mr. Gogoi, Kostov Gogoi. So,
no, first of all, making Treasury officer party you want. We make him.
Yes.
Then we ask Mr. Upamanyu, what is the next course of action? Heard Mr. B. D. Das, the Learned Senior Counsel, assisted by and Mr. D. Upamanyu appearing on behalf of the Higher Education Department. Mr. R.K. Talukde appears on behalf of the Accountant General. This is an application filed by the petitioner to implead the Treasury officer Amingam as the respondent number 5 to the instant writ petition, in view of the fact that the presence of the Treasury officer would be necessary for an effective adjudication of the incident matter. Taking into account the said submission and submission, taking into account the material, the state, taking into account the statements made in the averments made in the application, the instant this court deems it proper that it would be in the interest of justice to implead the Treasury officer Amin Gaon Treasury as the respondent number 5 to the instant proceedings. Accordingly, the registry is directed to make necessary correction in the cause title of the writ petition by incorporating the name of the Treasury officer Amin Gaon Treasury as the respondent number 5 to the instant proceedings. I stands accordingly disposed. Main petition. Heard Mr. B.D. Das, the learned senior counsel, assisted by Ms. R. Decker. Mr. D. Upamanyu appears on behalf of the Higher Education Department. Mr. R.K. Talukde appears on behalf of the Accountant General A.E. Mr. R. Bhupajari, who is present in the court, duly accepts notice on behalf of the newly impleaded respondent number 5. Extra copies of the writ petition be served upon him during the course of the day. Let the matter be again listed on
It was
well,
fixed on 27, madam.
on 27 okay, on 27/4/2023 along with
No,
27.
Treasury officer will take instruction.
Let the matter be again listed on 27/4/2023
RK Chaudhary will take
as
instruction.
already fixed by the order dated 30/3/2020.
Mr. Bhupajari will take instruction as regard my lord.
Yes,
As regard non-payment of DPF amount and the provisional pension.
then it is too early, isn't it?
No, they can take it.
He is yet to get the petition.
No, we have already served.
Huh?
We have already served.
Now, have you given the petition, writ petition?
Yes.
No, you have only served the IA.
One copy of the writ petition is given. I will be requiring one more extra copy.
I'll give. I'll put it, sir.
27, I will try, madam.
Yes. Who is appearing for which department?
Lordship, Higher Education Department.
Higher education. Yes. Why have you deducted this amount?
Lordship, in this matter, Mr. K. Gogoi appears, Lordship, due to some medical emergency, he had to go to Gurgaon, Lordship. He will be back on 24th, Lordship, and this matter will be taken up next week, Lordship.
The request of the council for
1 and 5, Lordship.
respondent number 1 and 5 matter stands adjourned till to 8th of May 2020.
Obliged, Lordship.
On which date the learned counsel for the respondent number 1 and 5 shall obtain the instruction in terms with the order dated
15/3/2023.
15/3/2023.
Obliged.
43. This will be same now, Mr. Day,
Yes, your lord.
with that judgment.
Yes.
Well, what is this?
That is the IA 38
Oh,
double
this review orders we are taking. Yes, what is this?
The IA is for substitution. 3855/2000.
Substituting whom?
Sean. Mother died. She claimed for pension and other pensionary benefits in her writ petition 7284/2016. She was died on 26/9/2021. Page 9 of the IA.
Mother.
Mother died.
Not be issued directed to release the family pension, gratuity, DCRG, and other admissible benefits after computing the total amount of service of the petitioner deceased husband. You are not entitled to family pension.
The other benefits, gratuity and other benefits. And there is a long calculation, my lord. They had, though PPO number has been already been issued, but pension effect from 2009, died in the year 1988.
But your case is limited now only to the
And my lord, I am paying for
gratuity of gratuity and DCRG. What is the difference between the both? The DCRG and gratuity?
Death come retirement benefit.
And what is the gratuity there?
Gratuity not paid.
Understood. Why are you asking for both? I think it is one and the same. Why are you asking gratuity and DCRG? One. And
as far
area of family pension, which the mother should have got.
My lord.
And what about the other one? Did your father get it?
No, husband not get.
Husband didn't get anything.
Only PPO number issued to the mother after his death.
Huh?
While the wife approached before his court, then only during pendency of this petition, PPO number has been issued with effect from 2009. But husband died on 28 to 1980. 88.
So how much is the family pension? Chalo. Heard Mr. Debora, the learned counsel for the petitioner. Applicant. Mr. Who appears for the Assam? Mr. A. Chakraborty appears for the state of Assam. Mr. Arbor Pujari appears for the finance department. Mr. R. Dhar appears on behalf of the accountant general. And who is the PWD? Mr. R. Dhar appears, another R. Dhar appears on behalf of the PWD department.
And finance also party, my lord.
Finance, I have made him, na? Mention about it. This is an application filed by the son of the petitioner. This is an application filed by the son of the petitioner. And again, the applicant herein is the son of the petitioner who expired on
26/9/2021.
26/9/2021. The applicant submits that he is the legal representative of late Kopiti Payang, the original petitioner. Taking into account that the right to sue survives to the applicant insofar as the area family pension as well as the DCRG benefit this court substitutes the applicant as the petitioner and substitutes the applicant against the original petitioner. Full stop. The registry shall make necessary correction of the records accordingly in the cause title. The I accordingly stands disposed.
The Commissioner Secretary Finance name, Commissioner Secretary Finance,
You want him? He's not a party here.
party by handwritten in the main.
Oh, he's there. Then what do you want?
Our name may be reflected in the cause list. Perhaps they have not served copy on us, madam.
Huh?
Perhaps they have not served copy on us. That's why our names are not there in the cause list. I don't know.
Heard in the main petition, heard Mr. D. Bora, the learned counsel for the petitioner, and Mr. R. Bapujari appearing on behalf of the respondent number 7, Finance Department. The learned counsel for the Finance Department submits that an extra copy of the writ petition be served upon him so that he can obtain instruction in the matter. Accordingly, no, sir. In that view of the matter, the petitioner is directed to serve an extra copy of the writ petition during the course of the day upon the learned counsel for the Finance Department. List the matter after 4 weeks.
Our name may be only
The registry shall show the name of Mr. R. Bapujari representing the respondent number 7.
and so obliged.
And about 37 for orders.
Yes, none appears. What is this? Why they are seeking review? This is the case where SP Roy has appeared. Yes, tell me. It was a consensus order. It was a order by which Mr. Chaudhary has duly accepted that he has no problem with the Schedule 4 property being sent on execution.
My lord, with all respect, my lord, Mr. Chaudhary was not engaged advocate in this case.
Then,
My lord,
why did he appear?
But he appeared, he submitted, my lord, that submission was wrong.
So I can't help it. Why did he appeal?
My lord,
Have you initiated proceedings before the Bar Council against him?
that we.
If you have not done it, then why should I? Go.
My lord,
Go and challenge it in the Supreme Court.
my lord,
There was a specific submission made at that point of time that you have no problem if the Schedule 4 is executed, but without disturbing the Schedule 3. So this court had no other option that had taken it.
Schedule 4, my lord. Schedule 4, my lord. With all respect, my lord, Schedule 4 land. The specific order was, my lord, 50% of the Schedule 4 land. And he said, my lord, 100%. That is not correct, my lord, prima facie. Lordship, that is the error apparent on the face of record. My lord, your lordship kindly see, my lord, the order dated, my lord, that is passed by this honorable court in second appeal number, my lord, 7 of 2001.
Now, see paragraph 20 at page 67.
Yes, my lord.
What does it say? The plaintiffs are entitled to
My lord,
50% on the basis of their right
yes.
of purchase, and the remaining 50% on the basis of the right of tenancy.
No, my lord.
So how much does the percentage have? It is 100 only.
No, my lord. Your lordship kindly come to the.
No. Is the plaintiff not entitled to this land? The declaration, isn't it being given that the plaintiff is entitled to 150%?
50% of Schedule 4 land. Lord, that is
Schedule 4 land on the basis of?
on the basis of title.
No, on the basis of right.
On the
Right
basis
title.
of title, yes.
And 50% and remaining 50%.
Yes.
The use of the word is remaining 50%
Yes.
for on the by the plaintiff number 3
Yes.
on the ground of tenancy. What remains? 50-50 is 100.
And my lord, no, my lord, the next line your lordship kindly read, my lord. My lord, the land, Schedule 4 land, as well as eviction of the defendant from 50% of the land in Schedule 4. This is the operative part.
Hence, while affirming the judgment and decree passed declaring the plaintiff's right in respect to 50% of the Schedule 4 land,
Yes.
and the plaintiff number 3 status as tenant in respect to the remaining 50% of the Schedule 4 land,
True, my
as
lord.
well as eviction of the defendants from 50% of the land in so and so. So here 50% of the defendant number 3 was, or plaintiff number 3 was already there, and as such the remaining eviction was another 50%.
50% of the tenancy, my lord, tenancy
Okay.
and the operative part, your lordship, see, my lord.
Here's your name, B.K. Sen.
My lord, your
Or
lordship.
Mr. B.K. Sen, the
My
learned
lord,
counsel appearing on behalf of the petitioner.
can I pray one thing, Lord?
To dismiss?
My Lord, dismiss, my Lord, in presence of Mr. Kaur.
No.
Your Lordship, kindly
Sorry.
consider this aspect, my Lord.
No.
My Lord, let him come, my Lord.
Sorry.
My Lord, your
Heard
Lordship,
Mr. BK Sen, the
kindly
learned
consider,
counsel
my Lord.
appearing on behalf of the petitioner.
My Lord, it is the desire of the client, my Lord, that
It should be dismissed at the hands of Mr. Dhar.
my Lord, that is the desire of
the
and that is
client.
my instruction. If your Lordship kindly consider.
Heard Mr. BK Sen, the learned counsel appearing on behalf of the subject. When this court had taken this court, upon perusal of the review petition, does not find a justifiable ground for entertaining the review application. However, Mr. BK Sen, the learned counsel, submits that it is the desire of the clients that the review petition be dismissed by this court when Mr. Endor appears. The learned counsel. When? Tomorrow? Monday? Tuesday?
But in the month of June, he is coming.
And Mr. BK Sen, the learned counsel appearing on behalf of the petitioner. I have perused the review application as well as the order dated 29/11/2021, passed in CRP IO number 231/2019. I have also perused the order dated judgment and order dated 15/5/2012 in RSA number 7/2001, and more particularly paragraph number 20 of the said judgment. Upon perusal of the same, this court does not find any grounds for review of the said judgment.
My Lord,
Accordingly, the review petition stands dismissed.
my Lord, I am banking on to decisions of the Supreme Court. That may kindly be, my Lord.
Go to the Supreme Court. This is better. Now, has he opened? Is his that thing working? Where is it?
Yes, he's operating, my lord.
He's operating. Yes, tell me, where is he? Mr. NJ Khatonia, he was very much present today in the court. Has he filed reply?
Yes, he has filed reply, my lord.
Chalo.
Reply also he has admitted.
Lordship, he had some difficulty, your Lordship.
Why?
He had to leave, your Lordship.
It's not 4:15.
Lordship. He had some personal difficulty.
Okay, let me review the order. We'll fix it for hearing and then we will take it up. Then he can very well argue.
Lordship.
Let me review the order and we'll fix it for hearing.
It may be on Tuesday, your Lordship.
What?
Tuesday, your Lordship.
This matter has been pending since long.
Lordship.
It's a review petition of 71/2022. If I remember, his specific case is that there were some wrong documents being placed which have resulted in, as regards the no objection.
Yes, ma'am. And there was a order for changing of the location, madam.
Yeah.
That
So
was-
these were there. And he had also filed an affidavit to them.
And that was not challenged in the writ petition, madam.
Yeah.
And in the writ petition, when in the reply also, he has admitted, yes, I received the order. madam.
Yeah.
Lordship, even in fact, his name is not reflected, your Lordship.
No, so, but he told you to mention the matter. That
No.
means he knows it.
No, your Lordship, because Lordship had asked for him, so that's why I had informed your Lordship.
Let's see the list. How is it? Heard Mr. P. Kotoki, the learned counsel, appearing on behalf of the petitioner. Mr.
I'm for 2, 3, and
So
5 and
appears
6.
on behalf of the respondent number 2, 3,
3, 5 and 6.
5, and 6. It, however, appears that the name of Mr. N.J. Katania, who represents the respondent number 1, have not been shown in the cause list, for which he is not present. List the matter on 27/4/2023 at 2 p.m. showing the name of Mr. N.J. Katani. We'll have it not on 27, we'll have it on 9th of May,
9th of May.
showing the name of
Tuesday.
41.
Yes, Mr. Singh.
Wait, little.
Yes. Have you got the money?
But I have got the money less by 15,000.
Huh?
Only 15,000. I have not got because my lord, that is wrong on our part.
On your
Because, my
part?
lord, yes.
Very
What
well.
happened, my lord?
We
have
give
given
you,
even
we direct them to pay you additional 15,000. Everybody is
Yes.
in it. And you impose cost upon you, 15,000 each. Upon the lawyer, it's because of you this has happened. We impose the cost upon you. You made, I have asked you specifically in the court, how much is the amount? You gave me this list, I have put it.
My lord, after committing that mistake, my lord, I have filed an additional affidavit before your lordship. At the time of passing the impugned order, my lord, your lordship did not consider that affidavit. That is actually in the additional affidavit I have clearly stated before your lordship.
Now tell me, how are you filing one application for review of so many orders? Are all the different petitions not different?
No, my lord, only order, but reference has been given, but impugned order is one. Others non need to be reviewed, my lord. Only I place before your lordship the order at page 96. That is the order impugned.
Page
96 to 2001.
Have you gotten money?
That money I have got.
Well,
immediately they have paid.
how much time did it take for getting that money? You filed the petition in 2021.
First pilot 50% was given. Next time I am to file the list of 50%, but instead of that, some less amount list has been placed before your lordship, and that was recorded by your lordship. Subsequently, I realized the mistake, my lord, and filed the additional affidavit. And that additional affidavit, my lord, is not considered by your lordship at the time of passing the impugned order.
Go to this division bench. No ground. I'm not considered, place it before the division bench. Let the division bench do it. Why should I do it?
No, my lord, your lordship will consider the additional affidavit.
No, I'm not going. I'm not considered. Not considered. Rightly or wrongly, I've not done it. Go to the division bench. Why should I?
No, my lord, your lordship, something on record, my lord, your lordship has not.
I'm not done it.
Taken into
It's
consideration.
something. It's a perversity. Let us assume it's a perversity.
My lord, your lordship.
Then
if your lordship,
why should I?
If your lordship considered that, I am not considering this additional affidavit. If that is reflected in the impugned order, my lord, that would have done. I do not have any ground. But specifically, my lord, before passing the impugned order, I realized the mistake. and file this additional affidavit saying that I have got 15,000 less than the real amount. So, my lord, if it is reflected in your lordship's order that actually I have gone through the additional affidavit, but also I have not considered.
I will say that at the time of hearing the matter, you did not place the additional affidavit. Matter?
No, my lord.
Go to the division bench.
Your lordship.
No, Mr.
can
Sheikh.
hear like this.
Nothing
but
doing.
Your lordship will consider.
No, I'm not going to
Let me
consider.
submit, my lord. Order will be passed by your lordship. No, my lord.
You have submitted. I've heard you.
But your lordship, that it is not placed before your lordship.
You have not
That
placed
will be
before me.
perverse on record, man.
Huh?
That will be perverse on record.
Very well, then go to the division bench for that.
Why it is
Well,
perverse
not
on
true.
record, my lord?
I would have considered if it is, no, Mr.
I
Sheikh,
have
if it
this
was a
additional
second
affidavit.
appeal or CRP, I would have considered this. No, not this one.
My lord.
You can very
That
well
will-
go to division bench.
That we can go, my lord, but there will be a harassment, my lord. Again,
Harassment,
again
it
and
is
again,
okay.
the
No
client is to
problem.
go. It's not, it is no problem, my lord, that because,
your-
my lord, that additional affidavit I have filed on certain date and your lordship passed the order, impugn order subsequently. So if it is held that
I
it is
passed the
placed-
order, you have not placed that document when I have taken up the matter.
additional affidavit,
That was not placed when I was taking up the matter.
but that will be perverse on record.
Let it be.
That will be perverse.
But you
on
have
record
not placed
because-
it.
Because, my
Mr.
lord,
Sheikh, I don't forget. You have not placed that.
my
You
lord,
file an additional affidavit out
thing
here.
is this, my lord, I was not present before your lordship.
Then
I was not present before
She
your
was
lordship.
present.
My junior was there. If I was available before your lordship, then possibly my
you
lord.
knew that was the
this is,
item number 1.
Yes,
Then
my lord, your lordship will be pleased to consider that if your lordship held that it is not placed before me when the impugn order was passed, that will be another perversity on record. Because, my lord, before passing the impugn order, I have filed the additional affidavit, and that affidavit was in record. Part of the record before your lordship, when your lordship passed the order. That is why, my lord, my ground is this. As I have filed the additional affidavit, that is not considered by your lordship at the time of passing the impugn judgment order. So, my lord, this is a vital document, my lord, that is to be considered. And your lordship would be pleased to see.
which is the additional affidavit at page 94?
Your lordship. Page 94, 95.
94 and 95. That is it.
Yes,
Who has signed it?
94, 95.
Who has signed it?
My client, my lord.
Understood. Who has signed it?
I'm giving.
So it is only one person,
Yes, my lord. Only
not for others.
not for others.
Only one person.
The review has been filed by 6 persons. Total 6 cases was there. 6 or 5. 5 cases. It is one of the petitioner, my lord.
Now, has the additional affidavit been filed by others?
Others also.
Where?
On same date, my lord.
You have not enclosed those.
Not, those are not enclosed here, my lord.
Then
Individual review petition has been filed.
there is only one review petition, or how many?
My lord, this is one review petition has been placed before your lordship. It is listed. Others are not listed
Okay.
today.
Let those be listed together.
Along with those.
Chalo, we'll issue notice.
My lord.
Heard Mr. M.A. Sheikh, the learned counsel, appearing on behalf of the petitioner. Issue notice making it returnable by 6 weeks.
Forty-six.
We have already issued the PPO and CTRG has also been written. Page 13 and 14, Lord, we have already issued the PPO.
You have done.
And gratuity
This is a case where the petitioner is not representing.
not represented.
Now, what has happened here? You have issued the PPO,
Lordship at page 13.
the family pension, no?
No.
Yes,
Petitioner is alive, Lord.
Hmm?
The person who was retired is alive, Lord.
Is it alive?
Alive.
So you have issued the PPO.
At page 13 and DCRG at page 14.
Page 13, 14 of what?
Of the writ petition, which he has an act of.
No, there's some problem. 13, 14, something is there. Why the petition has filed otherwise? PPO, I have seen it.
The
No,
Treasury
there's
officer-
some other problem. No.
Maybe the Treasury officer has not released, Lord. In the synopsis,
He's dead. No, he's dead. It's family pension. Mr. Dor, I remember this matter. This was a matter on that day Mr. Solia was there. Problem arises out here is because of the lawyer leaving this case halfway, and this court has no other way to connect with the petitioner counsel. Mr. Dhor, Mr. R. Dhor, the other side. Come to this side, please. You become the petitioner counsel. What is to be done here? Here, what has happened, let me tell you. This was a case where the wife, after there was a PPO issued, and also DCRG minus 40,000 or something has been issued. Now, you know the habit of the lawyers out here, without filing representation or anything, without moving the Treasury officer, they move the petition. This court initially issued the notice. After issuing notice, this court asks the authorities to come up. Authorities say that we don't know because there has been no representation submitted. At that point of time, the petitioner counsel who was there, he left the brief.
Yes, I remember, my lord. Yes.
You were there, na? The
I-
last
I-
day.
Yes.
Yes. Now, we don't have the petitioner's number in the records. The lawyer's number is there. What to do? Only thing which is required is the petitioner be informed that she needs to approach the Treasury office. That's all. What to do?
Otherwise, address is there, Lord.
Address is, if
Address is there, so it by register letter, he can be informed of.
But now who
is going to do that?
Who is going to do it, madam? It is
better to appoint one legal aid counsel, Lordship.
That is what he is. Yeah.
okay. I will do it, madam.
Yeah, Mr. R.
Arthur.
Ardha. That I know, but was there any more thing to separate you both?
1 and 2, Lord. I'm one, he's two.
My lord, then if my lord will put the whole name, Rahul Dhar.
Yes. Mr. Ardha, the learned counsel appearing on behalf of the Accountant General, and Mr. A. Chakravarti appearing on behalf of the Director of Pension. It appears that the petitioner herein is not represented by the counsel who was initially engaged. As would appear from the various orders being passed on 2/1/2023, 17/3/2023, 3/4/2023, and 12/4/2023. Mr. Arbor Pujari, the learned counsel appearing on behalf of the Finance Department as well as the Treasury Officer, submits that the petitioner herein is entitled to the remaining portion of the DCRG, that is an amount of rupees 43,064, as well as also to the family pension. But the same needs to be communicated. For the same sake, the petitioner is required to approach the Treasury officer for doing the needful. Taking into account that the petitioner is not being represented by any counsel, this court has requested Mr. Rahul Dhar, the learned counsel, and appoints him as an amicus so that the interest of the petitioner can be protected. The registry is directed to serve a copy of the instant petition to Mr. Ardhar. As well as any other details available so that the petitioner could be contacted. This is the matter again on 29th of May 2023. You see, the petitioner stays in Jharkhand.
But husband of the petitioner died on 25/5/2018 and PPO was issued on 2018.
Yes, that I know. And the remaining DCRG is only 43,000. But the petitioner council left it.
I will communicate. I will.
Good. Huh? What else? Any urgent matters? So many will all.
Item number 11. Item number 11.
11? What is it?
Matter, my lord, there is a direction to consider the break period to be regularized and salary for that period. My lord, regularize that period, but salary has not been considered, man.
Regularization means it was suspension or something?
No, there was break of service because of the wrong order of the authority.
Okay, so that has already been regularized.
Regularized.
But you have not been paid the salary.
Salary, my lord. So,
Yes, madam, you have instructions. Health and finance.
As per my verbal instructions, Lordship, he has got the benefit regarding regularization and the period of salary from 13/12/18 to 15/2.
He has got the you have got it.
Maybe he will get it.
You get your instructions.
Already that period is regularized, Lordship.
That is your verbal, na?
Verbal,
Get
Lordship.
written instructions. Heard Mr. A.R. Sigdar, the learned counsel, appearing on behalf of the petitioner. Ms. Deborah appears on behalf of the health department. The learned counsel appearing on behalf of the health department submits that she has received verbal instructions that the petitioners that the break-in service period of the petitioner have already been regularized, and as per her instructions, the petitioner have also got the benefit of the salary.
Right.
However, she submits that she would like to place written instructions in that regard. List the matter again on 3rd of May 2023, on which date the learned counsel for the health department shall produce the written instructions. Liberty is given to the petitioner to mention the matter for update.
Deeply
obliged.
Anything?
It was listed on my list.
Yes, you have paid the court fee for 45 people.
Sorry?
Have you paid the court fee for 45 people?
Actually, there is also one aspect, but the same institution, my lord, Hotel Brahmaputra.
Huh?
Hotel Brahmaputra, which was closed.
Okay.
Employee.
What happened to them?
Actually, it was closed by the. It was a joint venture between the central government and state government for 30 years. After 30 years, although the central government intended to continue, but the state government closed the matter, and all these persons were asked to compulsory retirement with some severance packages, and they are in the last day of their service is November 2017, and they were paid as
6th pay commission. Thereafter, the 7th pay commission came into force with effect from 1st of April 2016. And since 2016 April till November 2017, they were in service, so they are entitled to that period as area salary first. Secondly, the severance package was given as per the 6th pay commission for 15 months, 30 months, sorry, of their total services, up 50%, and that is to be revised. Thirdly, they were saying that 3 months prior notice period will be salary will be given. That was not given. And another prayer is there. Medical.
When were you given the notice? 3 months prior?
Actually, initially, as per the order of the department, the hotel was to be closed with effective from 31st of August 2017. Order was passed. But the hotel was continued up to November. I worked there till November 2017.
But when were you issued the notice?
Actually, no formal notice was issued. Only a fixed format, Annexer A, was served to be filled up and signed and to be submitted before the authority. And it was given.
What is the date of that?
Actually, these copies were submitted before the authority, and I only have the format.
Okay.
So it is a compulsory retirement. So first thing is that there is no scope of getting me to change that thing. Secondly, the sick leave, that is also not paid because it is a compulsory retirement. Although
You were government of Assam employees or some corporation employees?
actually ITDC.
Ah.
But it is.
You won't come under the 56. Would you come under 56?
My lord, because
they were employees of my lord erstwhile Hotel Brahmaputra also.
That I could know.
Yes. Now, upon closure of that, my lord, establishment, my lord, they were given some benefits. Now, they are not happy with the benefits, therefore they are before this court. Now, it appears from the materials on record, my lord, annexed with the writ petition that already a conciliation proceeding had taken place before the Labour Commissioner.
That was a priority.
Conciliation.
Now, what has happened there?
Nothing.
But do they come under the ambit of workmen?
Ambit of workmen, my lord, otherwise it may be an industrial dispute.
There were some issues prior to the closure. The date
because
of
closure benefits now, my lord, giving closure notice, retrenchment, all these things, my lord, detailed procedure is there in the Industrial Disputes Act.
Understood. But would they come within the ambit of in the workmen?
It appears to be so because at one point of time proceedings were initiated before the commissioner, Labour Commissioner. It is there in the writ petition.
That was not about
conciliation proceeding. Now
So would they not be entitled to this 35 or 33G or something? What is that?
Then
Industrial Disputes Act.
Then, my lord, they will have to raise an industrial dispute, my lord. That can only be adjudicated. I am not on preliminary. This will be my submission.
No, if it is there, it will be a case of there is two things. One is a golden handshake, or the other is a retrenchment.
Yes. Now here is a case of golden handshake.
There's a golden handshake. They've accepted it without any problem.
No, they have accepted it, but with some ifs and buts. So therefore.
And ifs and buts has a reason subsequently or at the time of accepting?
Subsequently.
My lord, both proceedings.
And hence, my lord, this conciliation proceedings. Before the Labour Commissioner.
Then my lord, question of evidence will come to page number 30. And it is the order managing director, Assam Tourism Development Corporation. Actually, the thing is that it is a joint venture. 51% of total share is with the central government, 49% with the state government. And my service is regularized, considered under the state government. And ATDC considered pays my salary.
And
But Mr. Counsel, you have to understand, you are under a corporation. When you are under a corporation, the parameters would be different. A defunct corporation or a corporation who may not like to who would like to sever its ties, there are two ways, either by a golden handshake or by a retrenchment.
But I am not on the continuance of the order. I am only whether 7th pay commission will be applicable to me to these two parts. First thing,
How do you apply 7th pay commission?
because I am under the.
Do you have the ROP rules of 17
My lord, it is in my mobile.
in your pocket?
I have checked it today also.
See how ROP is applied to corporations. ROP is directly not applied to corporations. It has to be by a specific order. Then how do you get the 7th pay commission if it is not applied?
But as my instruction, the Assam Tourism Corporation Limited is to many extent is under the state government.
Understood, but if you see the ROP rules, if I've done a lot of matters pertaining to the 2010 rules. Now this will be under the 2017 rules. The 2010 rules, it makes it very clear. I remember it categorically that this is only applicable to the state government employees. However, in respect to other undertakings, it has to be on the basis of a specific order of the government. Then only it can be applied. Now, if that has not been done, how will you entitle to the 7th pay commission? If you have severed your ties prior to that.
But the whole severance package they offered me, it is under the 6th pay commission. They also mentioned.
Understood, but was the 7th pay commission applied to the corporation? That is, look into that. You have keeping the ROP in your pocket won't help you.
Actually, I have one copy. Actually, the file is with.
You have to get the ROP out. ROP 2017.
We will have to, my lord, satisfy two things, that ROP has been adopted, number one, at the first instance. Secondly, it has been ratified by the government.
No, it has to be on the specific order of the government.
Yes, no,
Otherwise, it can't.
Therefore, adoption and ratification.
And more particularly in 2010, I think it was in 2011. For 2010, it was in 2011 or 12. I don't remember the date of 7/6/2011 or 12. There was a particular notification issued how in respect to corporation, how the corporations are also categorized, A, B, C, and each category how ROP will be applied. What are the requirements? Like in category A, it is the requirement that you have to have the audits done every year. These are all requirements. So that is how it is being extended. It is not extended immediately.
But on the last occasion, they prayed for filing affidavit. If they can file that.
With all these problems being pointed out, they may not like to file. Okay, when do you want it? You look into that, these aspects. When?
3rd or 4th of May.
Hello, we'll have it on 10th of May. Heard, Mr. D.K. Nath, the learned counsel for the petitioner, Mr. R. Borpuzari, appears for the finance department. Stop.
Well, my
Let them-
colleague,
Respond number 4.
Your name?
Respond number 4.
Your name?
PK Sharma.
And so appears on behalf of the rest. What is response number 4?
Assam Tourism Development Corporation.
Assam Tourism Development Corporation. When was the ROP extended to you?
I am not to
Get yourself aware of that. You are appearing out here. You should know that. And that is his basic case.
Yes.
Yes.
I'll do that. I've heard.
The learned counsel for the Assam Tourism Development Corporation. Development or
Development.
Tourism Development Corporation shall apprise this court on the next date as to when the Assam ROP rules 2017 was made applicable to the Assam Tourism Development Corporation by the state government. Was to place the matter again on 10th of May 2023. Anything else, Mr. Ghosh?
I actually mentioned item number 18, my lord.
Yes.
So, the stipendary, the lordship I picked up any other, the third or fourth, fifth
Stipendary?
teacher, my lord, because that left out of the series, my lord.
Show me. We'll dispose it of now. Oh, we still have time. Half an hour is there.
Oh, no ship.
Heard Mr. B.J. Ghosh, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. Mr. Arbo Pujari appears on behalf of... Why you bring a pension is also required? Arbo Pujari appears on behalf of the Finance Department. And Miss A. Talukdar appears on behalf of the Director of Pension. The case of the petitioner herein is that the petitioner pursuant to a selection proceeding was appointed as temporarily as a stipendiary teacher by an order dated 30/1/1996. Subsequent thereto, on the basis of an order dated 3/4/2001 issued by the Deputy Inspector of School, the petitioner why are you appointed twice?
This was actually regularized
He also speaks of that Monohoran committee. Perhaps his appointment was not regular, my lord.
It was regularized, my lord, left alone.
When did you get your salary? Did you continue to get your salary all along?
Yes, my lord, 1800 stipendary. Then, my lord,
Okay, allowed to draw regular scale of pay under PB2 with effect from 20 by so and so month.
one is of 2004, 17/2004.
You were appointed against which vacancy? The problem arises with this, as I could see in all cases, all teachers, these are done against vacant posts.
Yes, my lord, here lordship will find, if your lordship kindly look page 33, Gunotiti Hati Borua, assistant is allowed to draw against the retired
So
vacancy of.
this order was, you were regularized
Yes,
on 3/4/2001.
yes.
It further appears that by an order dated 3/4/2001, the services of the petitioner was regularized against the post created by government order dated number LNA/158/94 dated 18/1/1995 and DEE's allotment of post number MPD/OB/1/95/9 dated 12/4/1994. It further appears that on 1/7/2004, the Deputy Inspector of Schools was selected, the Deputy Inspector of Schools in his order observed that the petitioner, that the services of the petitioner was selected by the Monohoran committee and was allowed to draw pay with effect from 1/5/2004 as per government order number A/I Roman I, capital I, E 425/95/PT -Roman 2/140 dated 10/8/2000. No, Mr. Something, you have to look into it. This is not so easy.
No, the department also has filed an affidavit.
What does it say? No, the department don't deny that. Department is okay with his appointment. Only there was a delay in the issuing giving him the benefit. He has been given the regular scale of pay from
2012.
2012.
Yes. But actually it was given from the.
Huh?
But actually I received it from April 2015 only. Though, my lord, by this office memorandum of 2015, my lord, benefit was given from 2012, but it actually paid to me from April 2015. So I have another claim for that payment of the arrear also.
And what are these challenging these orders? Conferential orders dated 10/9/2015, 19/12/2015, 29/12/2015, and 9/2/2016. What are these?
In terms of the office memorandum of 227 to 82, that is, my lord, regarding that confirmation of my service. Nothing to do with that NP, that my lord pension scheme. Because the lordship has already held the patent portion, my lord, that was just but
No, see, paragraph 8
my lord.
of the affidavit says
Yes, ma'am.
that petitioner was allowed to draw regular scale of pay with effect from 2010-2012.
Yes, my lord.
Then are you not getting it?
I received it only from 2015, April 2015.
So that amount is there.
That area that is there, my lord.
So that amount you are making a claim.
Claim, my lord. Beside, my lord, that Assam service pension benefit under a.
You are entitled to, but you have not been given.
Yes, my.
But this aspect would have to be verified.
My lord, what I respectfully submit,
Huh.
Covered under the Assam service pension rules of 1969. If I am covered, so far DST is concerned, my lord, lordship may make a liberty to approve them by an application. They will consider it after verification. And if I am entitled for that period, they may pay. If I am not, because my lord, because if it is not decided or my lord left open, I can't file a second writ petition on the same subject. Lordship is aware. It may hit by the principle of res judicata also. That is my apprehension.
Primary claim, my lord, with regard to whether he will come under the old pension and leave. Ancillary claim that falls from, my lord, page 54 of the writ petition. 54 is the office memorandum on the basis of which he is claiming.
Yes,
That I know, that I've understood that. Chalo, we'll take it on, pass the remaining part on 27. Let the matter be listed on 25. I mean, 26, 27, 27 for 2023 at 2 p.m. Beginning my reckoning. What is this 12 business now?
Just praying for a simple mandamus to release my arrear increment. I thought already the proposal has been sent from the district.
Hello, let the matter come some other day.
Just praying for a date. That's all.
Hmm?
Only for a date.
Oh, you want a date? Ask him, he will give you a date.
No problem.